All right, good morning, everyone. Back on record, State of Ohio versus Melissa R. Norris. Remind everybody to turn off their cell phones. The state rested yesterday, and we are now prepared to move forward. Defense reserved the opening statement. Do you wish to present an opening statement this time?
We do, Your Honor.
All right.
Please, court opposing counsel. Ladies and gentlemen, one of the first things that you heard Judge Cost tell you yesterday was that you can't hold it against a defendant if they choose not to testify. You can't consider it. I've always thought that's probably an impossibility, but here it's not a consideration. You won't have to even think about that because sometime I would expect fairly soon this morning, Melissa Norris is going to get up on this witness stand and tell you what happened on that horrible day. She's going to tell you that she took John Norris's life, that she had this gun and that she pulled the trigger and he did pass away. There will be no argument about that. What there will be is an argument as to why she did it. That's the big why. And what we're saying is that she did this in self-defense. After hearing all of yesterday's testimony, that's the state's case at this point, and it doesn't look that great. But now it's Melissa's turn to tell you what happened down there. If you can imagine, because I can't, what it would be like to have shot somebody, what would be going on through your mind at that point in time. I believe the evidence will show that there's probably gaps in her memory. There may be places over the last several months where she has been less than honest. We believe the evidence will show that she was being assaulted. The only person that was in that room after Haley Pollard left and heard her testimony was Melissa and the decedent. So Melissa is the only person that we have that will tell you her story and what happened. We believe the evidence will show that she was being assaulted and that all she wanted to do was get him off of her. The gun was fired and he passed away. She wanted to keep him off of her. She never intended to kill this guy. But unfortunately, that's the situation she finds herself in today. So once you've heard all of that, we believe the only conclusion that you will come to, and this is a tough swallow, I understand it, because we've got a dead person, but that she's not guilty of murder, and that's what we're asking you to find today.
All right, thank you. First witness.
Your Honor, defense would call Brian Lamb. I believe he's in the DR courtroom, Your Honor.
Pardon me?
He's in the DR courtroom.
All right.
We're getting him.
Thank you.
Were you sworn in the clerk's office?
No, sir.
Okay, would you raise your right hand, please?
Yes, sir.
You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir, I do.
All right, you can have a seat over there. If you have a cell phone, make sure it's off.
I did. Yes, sir.
Okay, and then pull that microphone clear over to your left, please. You got to slide that way.
It's like, oh, okay, thank you.
All
Yep.
right, you may inquire.
Thank you, Your Honor. Sir, please state your name for the record.
Brian Lamb,
Where do you reside?
Fostoria, Ohio.
Sir, who subpoenaed you here today?
I got,
Objection, relevance.
Pardon me?
I
What was
said
the question?
objection, relevance.
What was the question?
Ask if he was subpoenaed here today.
Okay, it's sustained. Move on.
Sir, where do you reside? I'm sorry.
Fostoria, Ohio.
Okay. Where were you the morning of March 11th, 2023?
I was at my wife's apartment at 801 Treewood Drive, apartment number 8.
Okay. And is that here in Hillsborough, Ohio?
Yes, sir.
Okay. And why were you at the apartment number 8 at Treewood on March 11th, 2023?
I was cleaning my wife's apartment. She was moving out. We had gotten separated the year prior, and we were working, getting our marriage back, and she was moving out, and I was helping her clean the apartment to get her deposit back.
Okay. And what time, or what, if you recall, what time during the day were you there? What time did you get there?
I'm not sure the exact time. I know I had to work the next day. So what I usually do is when I come down and see my wife, I would, because it's like a 3-hour drive up there, I would spend the night, then I would get up at 2 in the morning, and then get ready, leave by 3, and I could be up north by 6, and I would eat breakfast with my family, then head to work. But I know it was probably either early morning or afternoon when I got there to clean, because we had everything moved out, and then we just had to clean the oven yet because she had all new appliances. We wanted to make sure they was nice when she left.
Okay. And do you recall an incident that occurred that day?
Yes, sir. Yes, sir.
Okay. Can you please explain to me?
Yes, sir. When I got there was a younger lady sitting on the steps outside Mr. Norris's door, because his apartment door was right at the bottom of the steps, and my wife's apartment was directly above his, and she had a purse there, and I said, excuse me, and she said, oh, I'm sorry, let me get out of your way. I said, no problem. So I went up and started cleaning, and then I'm not sure how long I was there before, but I heard yelling, and something about someone was lying or something, and then I heard a scuffle, and I heard stuff being knocked over, and then I heard a woman's voice say, get the F word off of me. And I had oven cleaner on I had to wear them crazy looking gloves, and I was like, I had it all over me. I was trying to really get it clean. So then I went over to the sink and ripped them off real quick, and then I heard the door slam, and I thought, and in my mind I processed it, because then it got quiet, and I processed it, okay, she left. The girl had left, things calmed down. So I stood there for a little bit, and I was like, okay. So then I heard more stuff moving, and in my mind I processed it, and Mr. Norris was like picking up whatever got knocked over or thrown around. And then I heard a boom, and I thought maybe he was mad and punched a door or something. And then a little bit later, I heard a policeman's radio out in the hallway, and I was like, okay. So I opened up the door, and he said, did you hear anything? I said, yes, sir. He said, where at? I said, directly below us. He said, okay. So then I shut the door, and then a little while later, he came up and said, would you be willing to fill out a statement? I said, yes, sir, I would. And then I still had not known at that time what had happened.
So you gave a written statement
Yes,
to
sir. Yes,
the Hillsborough
sir.
Police Department that day?
Yes, sir.
I want to back up for a second. You indicate you testified that you heard a scuffle.
Yes, sir.
Okay. Can you describe that to me?
It sounded like stuff getting knocked over. I've never been in his apartment. It sounded to me like maybe a coffee table or a kitchen chair table, something. It just like, there was lots of yelling, and I was like, oh my goodness. But yes, sir, it just sounded like, people were fighting. It sounded like.
And I'm not trying to make you say a curse word here, but it's important in this case. You indicated earlier that you heard a woman's voice
Yes,
say
sir.
something.
Yeah, she said.
Specifically, what did you hear?
I heard her say, yes.
Objection.
Sustained.
Does that mean I answered or no?
You do not answer.
Okay, thank you.
Remember when we approach?
All right.
And you may have said it, sir, again, I apologize. After the scuffle ended, how much time elapsed until you saw Hillsborough PD?
I can't say. I'm not really sure. It just seemed like, I'm really not sure. I'd be guessing if I
And I get that.
set a time
Okay.
on it.
No more questions, Your Honor.
Cross.
Thank you. Mr. Lamb, I'm Annika Collins, the county prosecutor.
Yes,
who
ma'am.
spoke on the phone.
Yes, ma'am.
You don't know what time it was that you were there?
No, ma'am, it was 9 months ago.
Okay. You don't know what time it is that you saw the young lady on the steps when you got there?
It was when I first got there, but no, ma'am.
Don't even know if it was in the morning or the afternoon?
I would say early morning or maybe around noon, somewhere in
Maybe
that.
around noon or-
Maybe somewhere around then.
Okay.
Yep.
You don't know what time it was that you heard the door slam and assumed someone left the apartment?
No, I didn't look at my watch, no, ma'am.
How long after you heard the door slam did you hear the loud boom?
Yeah, I'm not sure, because the boom came after the door slammed, I heard more stuff moving around, and I assumed Mr. Norris was picking stuff up.
Do you recall speaking with me on the phone
Yes, ma'am.
previously? Do you
Yes, ma'am.
recall telling me it was seconds?
No, ma'am.
Okay.
No.
And after the boom, your testimony is that you heard things moving around again?
Yes, ma'am.
And your testimony is that it was a table being knocked over and a chair being knocked over?
I said I assumed that's what it was, what it
Okay,
sounded
so you really
like.
don't have any idea what
Correct.
was going on?
Yes, ma'am, that's correct.
No idea what happened in the apartment below?
Correct.
You can't say today how many people were in there, who was, you have no clue?
That's correct.
No further questions.
Redirect.
A moment, Your Honor.
Nothing, Your Honor.
All right, you're excused, Mr. Manning, thank you.
Thank you.
Next witness.
Call Melissa Norris, Your Honor.
Would you raise your right hand and be sworn, please? You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Have a seat over there, and pull the microphone over in front of you, please. Raise your hand, Clark.
Thank you. Ma'am, please state your name for the record.
Melissa Norris,
Melissa, where were you on March 10th, 2023?
John Norris's,
And I'm sorry, Melissa, I can barely hear you. Make sure you speak up.
801 Treewood Drive, John Norris's,
Okay. And how do you know Johnny Norris?
my brother-in-law,
Okay. And how long have you known him?
ex-brother-in-law.
I'm having trouble hearing. Keep your voice up. Lean into the microphone if you will.
He's my ex-brother-in-law,
Okay. And how long would you have known John?
25 plus years.
Okay. And why were you at his apartment? Or let me ask you this. When did you get to his apartment?
On March 9th,
Okay. And why were you there?
he was giving me a place to stay.
Your Honor, I can't hear
Yeah,
her.
you're going to have to speak up and speak into the microphone, get a little closer to it.
He was giving me a place to stay.
Okay. So you got there March 9th? And you spent the night
Yes.
March 9th?
Yes,
And you stayed there March 10th?
yes,
And did you spend the night March 10th?
yes.
Okay. So were you there on the morning of March 11th?
Yes.
Okay. Do you recall what time you woke up?
Roughly 10:30, 11.
Okay. And what did you do when you woke up that day?
I got up, got in a shower, come out. I hadn't been out of the shower probably 10, 15 minutes, and I heard a knock on the door.
Okay. When you woke up that day and took your shower, was John awake at that time?
No,
And where did you sleep? Describe to me where John was sleeping at, where you were sleeping at.
there's two recliners in the living room, and he was in one and I was in the other.
Okay. And you saw yesterday there were some different pictures, okay? And there was a recliner, I'll say, closest to the kitchenette. Then there was one closest to a sliding door. I'm assuming that's the patio. Can you describe to us which one you slept in and which one John was in?
The one closest to the patio I was in, the one near the kitchen he was in.
Okay. And you indicated, I think, after you took a shower, you heard a door, someone knock at the door.
Yeah,
Okay. And did you answer the door that day?
yes,
Okay. Who was at the door?
Haley,
And again, for our purposes here, who's Haley?
my daughter.
Okay. And why was she there? Do you know?
I don't know why she was there. She knocked on the door and I answered it.
I'm sorry,
I answered the door and she come in.
okay. So Haley entered the apartment that day?
Yes,
Okay. When Haley entered the apartment, was John up?
no,
Okay. At some point in time when Haley was in the apartment, did John awake?
Yes.
Okay. Do you recall how long she was there before John woke up?
She come in, and I was just whispering, keeping my voice down because he was still asleep. And I think he heard us talking, so we went into the living room, so maybe a minute.
Okay. Do you recall what John did when he woke up?
I think he got up and made a pot of coffee.
Okay. Now, you've heard testimony of Haley yesterday, and there was discussion over a dispute, or whatever you want to call it, of a red shirt. Was there an argument or a dispute over a Cincinnati red shirt?
No, I mean, she had mentioned his shirt, that she liked his shirt. And I said, oh, wasn't that Garrett's shirt?
And who is Garrett?
Garrett is my son.
Okay. So I'm sorry, I cut you off.
No, you're fine.
Please go forward.
And I said, isn't that Garrett's shirt? And he said aggressively, no, it's mine. And I'm like, okay. I said, well, isn't that Garrett's bat sitting there? And I go to reach for it just to,
Hang on real quick.
okay.
So did the discussion or whatever the debate or argument shift from the shirt to a ball bat now?
I mean, there wasn't really no argument other than him just he was aggressive with it, like it made him mad that I said that was,
Objection calls for speculation.
Sustained.
What was John's behavior during this dispute?
aggressive, angry.
Okay. And so you mentioned the ball bat.
Yes.
What was the discussion concerning the ball bat?
I said, isn't that, oh, that's not Garrett's bat, because it was a red shirt, so I just kind of put two and two together, thought maybe that was his bat because Johnny had stayed at the house prior, he lived out there, so he helped take care of Garrett and he was around a lot, so they might swap clothes or, whatever have you. And, but the bat, I went to reach for the bat.
Real quick, I'm gonna stop you. Where were you when this discussion was occurring?
In the doorway between the kitchenette and the living room.
Okay. How far away from John?
Probably 6 feet maybe.
Okay. So you said you went to reach for the bat.
Yes.
Okay. When you reached for the bat, what happened?
He was standing there after I'd commented on the shirt, and he said, no, that was mine. I said, wasn't that Garrett's bat? I went to reach for it, and he lunged toward me. And when he lunged at me, there was a bat standing against the wall, and there was a gun. And when I reached for the gun, where he lunged at me, it knocked my hand into the gun. So I was setting it back up. As I sat it back up, he snatched it out of my hand.
Snatched what from your hands?
The gun.
Okay. Now, just so I'm clear, when you were talking about the bat, you indicate, did you reach for the bat?
Yes.
Okay. And you said somehow the gun slid or was hit?
Yes, because the bat's standing here and the gun's here. When I'm reaching this direction, I reached for the bat, and as I reached for the bat, and he lunged toward me, it knocked that gun over. So, and it's pretty big, so I just was setting it back up, and as I grabbed it, kind of catching it or whatever, he grabbed it out of my hand.
Okay. Now, was Haley present during this interaction?
I couldn't tell you when she left.
Okay, so you don't know, or do you recall either way?
Pardon me?
Do you recall if she was there or not during this incident?
I believe she was, but I'm not clear.
Okay. You heard testimony yesterday from your daughter
Yes,
that you grabbed the bat.
yes,
Did you and John ever get into a struggle over a baseball bat?
absolutely not,
Okay. Did you strike John with a baseball bat?
absolutely not,
Did you swing a baseball bat at John?
no,
Okay. So you indicated after you set the gun up, John grabbed the gun, is that correct?
Yes.
Okay. After he grabbed the gun, what did you do?
I was like, it scared me, the way he was, because he was so aggressive about it, it scared me, and I thought, I'm getting the hell out of here. So,
So you indicated, you said you're getting, was this in your mind, I'm leaving?
yes.
Okay. Why were you wanting to leave the apartment?
Because the way he was aggressive about the T-shirt, making a big deal out of it, and then when over the bat and then hitting the gun, and the way he grabbed that out of my hand, it scared me. It scared me.
Okay. So what did you do?
I ran for the door.
Okay. So how far away from where you were standing, if you recall, was the door?
Me to your table,
Okay.
probably.
I mean, would you say 10 to 12 feet?
Yeah, me to Bill, probably.
Okay. And so when you made a beeline to the door, were you able to leave?
No,
Why were you not able to leave?
because he was standing in front of the door with the gun. He met me there. It's like he met me there at the same time, like he was stopping me, and he cut me off.
So please describe that for me. So you go to the door,
I'm going for the door.
okay, and where was John?
John was coming around the living room side, and as he come around the living room side, he met me at the door and was standing there with the gun. And he threw the gun and just grabbed me.
So when you were at the door, what happened?
I get to the door, and he had that gun. I seen him throw it, and then he grabbed a hold of me and slammed me to the ground, bashing my head on the floor. It was, I don't know, it was bad.
Okay. So you indicate John took you to the ground?
Yes,
Now, you saw photographs yesterday during the testimony
yes,
of a laceration and swelling to your right eye.
yes,
Did you have those prior
no,
to John taking you to the ground?
no,
Okay. Did you receive those as a result of this attack?
yes.
Okay. Now, you indicate John took you to the ground. Do you recall how long he had you on the ground?
It felt like forever.
But you can't put a time period on it?
No, a minute, two.
Okay. Now, do you recall how or when the attack ended?
It went on so long, I mean, it was like we started scuffling, and I ended up in the living room, and I don't recall, like, he just, I don't know, I was fighting him. I remember being combative. I remember scratching, hitting, fighting him back, and next thing I know, he's getting off. I'm cussing him. I'm hollering at him. I told him, I said, I'm calling the law, is what I said, and that's when he got up off me.
And at any point did you grab the gun?
Yes,
Why did you grab the gun, Melissa?
because I was scared he was coming back at me again.
Okay. Where were you at when you grabbed the gun?
In the living room,
Okay. And where was John?
coming around the corner, coming towards me.
Okay. Melissa, did you shoot John Norris?
Yes,
Okay. Why did you shoot John Norris, Melissa?
because I was scared to death.
Okay. What was going through your head at that moment?
I was just so shook up and so scared. I mean, it just happened so fast. I mean, you don't think. It's just out of fear, out of scare, I just grabbed it. It's just, I don't know. I seen it laying there. I seen him coming back towards me, and I just grabbed it.
After you shot the gun, you stayed at the apartment, is that correct? Why did you stay there?
I don't know. I mean, I was just so in shock, I think. I mean,
Do you remember having contact with Officer Butler or Paint Creek EMS that day?
vaguely,
Okay. Do you recall being treated by the Paint Creek EMS?
I mean, I remember someone asked me if I was okay. And I didn't want to be touched. I just didn't, I don't know. I just had been assaulted and I don't know. I just didn't want to be touched or bothered. I just felt like curling up in a ball. I was just freaked out.
Okay. And you indicated just a second ago you were assaulted. As a result of that assault, what injuries did you sustain?
I had a couple knots on my head, my back, my left arm. I had some, like, my hip was hurting. I mean, I was pretty banged up.
Melissa, were you in fear of your life that day?
Yes.
No further questions, Your Honor.
Cross?
Ms. Norris, I'm Annika Collins. I'm the prosecutor. I'm going to ask you some questions. So let's go way back to the beginning. Jerry Norris is your ex-husband, correct?
Yes.
And Jerry and John are brothers, correct?
Yes.
And you and Jerry have a son together named Garrett, correct?
Yes.
Jerry took you to John's apartment to stay, correct?
Not necessarily to stay, but
Well, you needed a place to stay, correct?
yes.
And so he took you to John's apartment, correct?
Yes.
Okay. So he took you there so that you could stay there, correct? It's not complicated. That's
Yes.
correct, yes.
Yes.
Now, before he took you there, he bought you a cell phone, didn't he?
Yes.
So during the time that you were at John's apartment, you had your own cell phone, correct?
Yes.
Now, on March 9th, which would have been a Thursday, you, Kyle, and John all stayed at the apartment together, correct?
Yes.
And on March the 10th, you and John were the only two that stayed at the apartment, correct?
Yes. I believe so.
So on March the 11th, sometime in the afternoon, Haley came to the apartment, correct?
Yes.
This would be Saturday, correct?
Yes.
What time did Haley get to the apartment?
Roughly around noon.
I can't hear you.
Roughly around noon.
I'm going to wait just a second, Judge. So after she gets there, you and John get into an argument, correct?
Yes.
And you get into an argument about a T-shirt, correct? The Cincinnati Reds T-shirt?
If you want to call it an argument.
So you got into an argument about a Cincinnati Reds T-shirt, correct?
Wasn't an argument, no.
You get into a heated discussion.
No.
Okay. And then Haley left the apartment, correct?
I believe so, yes.
Okay. And then it was just you and John in the apartment, correct?
As to my knowledge.
Now, there are a multitude of pill bottles sitting beside John's recliner, correct?
I don't know.
You didn't see those?
That's his private, personal, I mean, I don't pay much attention to what he,
And he has a walker sitting close to the recliner there, correct?
there is a walker sitting there, near the patio, not near his chair. I don't believe he uses it, but
You don't have any idea. You know that he had back surgery 3 months before this, correct?
yeah, I
Let-
believe he had some medical issues, is all I know.
And you know that John weighed 134 pounds when you shot and killed him, correct?
No,
You didn't know that?
no.
Well, would you like to look at his autopsy report?
I didn't know his weight, ma'am.
He's thin, wasn't he?
Um,
Did you see him?
yes,
Was he thin?
yes,
Okay. Unhealthy, correct?
I'm not a doctor.
But you do know that he had had back and neck surgery like 2 months before this?
No, I did not.
You didn't know that?
No, ma'am.
Now, you became convinced that that Reds t-shirt was Garrett's, didn't you?
There wasn't, what do you mean convinced?
You believed it was Garrett's t-shirt, didn't you?
No,
It angered you that that John was wearing Garrett's t-shirt, didn't it?
no,
You became so enraged with him that you picked up a baseball bat, didn't you?
no,
You didn't grab that baseball bat.
no, ma'am.
So everything Haley said yesterday is a lie. You're calling your daughter a liar.
As far as grabbing the bat and that, yes.
And then Johnny asked Haley to call the cops, didn't he?
I didn't hear it. No.
Well, did you hear Haley testify to that? Yes or no? Did you hear Haley testify to that?
No,
You didn't hear her say that?
no,
Okay. And then Haley left the apartment after you grabbed the baseball bat, correct?
I'm not sure when she left.
Okay. Now, when Haley left, let me ask you this. Do you know what the dog's name was?
No,
If I told you it was Duke, would you agree with me?
yes,
Okay. So when Haley left, Duke was outside, correct?
I have no idea.
You don't recall putting him outside?
Absolutely no.
Okay. And then you grabbed the shotgun and you pointed it at Johnny, correct?
No,
You didn't do that?
no,
Okay. So, and you've heard the 911 call, haven't you?
yes.
And that's your voice on the 911 call? Yes or no?
I don't know.
Okay, well, let's break it down like this. Who was in the apartment after Haley left?
I don't know.
You don't know who was in the apartment?
No, I don't. That's not my apartment. I don't live there.
Well, had you stayed there that night?
Yes.
And had you been there all day that day?
That morning I got in the shower. I'd been in the shower, you know.
Are you expecting this jury to believe that there was somebody else in the apartment other than you and John?
No.
Okay, so it's just you and John in the apartment, correct?
To my knowledge, yes.
Okay. Did you hear the 911 call?
Yes.
Do you hear your voice on the 911 call?
Yeah. It sounds like me.
It does? And you hear your voice saying, "You don't think I'll do it, do you?"
Yes.
Okay. And you hear Johnny saying, "I've had a gun pulled on me in my own apartment."
Yes.
And then after the gunshot, you say, "How do you clear this thing?" Did you hear that?
I heard something on there.
Is that what you said?
No.
What'd you say?
I didn't say anything.
Oh, okay. That's not your voice on there?
No.
So it's the magical person that's in the apartment that it's somebody else in the apartment?
Who's the magical person?
I'm asking you.
Not to my
There are
knowledge.
2 people in the apartment, correct?
Yes.
A male and a female.
Yes.
There are 2 people's voices on the 911 call, correct? Other than the dispatcher.
To my knowledge.
2 people, a male and a female.
Sounds like it.
Okay. So your voice and Johnny's voice begging for help.
Sounds like it.
Okay. And it's not your voice saying, "Get off me, I need help," or anything like that, is it? You're not saying that, are you?
No, it had already been said.
Okay. So then after you fire the gun, you say, "How do you clear this thing?"
No.
Because the gun had jammed, hadn't it?
I have no idea. I'm not knowledgeable about guns.
But you picked it up and shot him.
I was scared to death.
I'm sorry. Did you pick the gun up and shoot him, yes or no?
Yes.
Okay. And that's your voice at the beginning of the phone call before he asks for help saying, "You don't think I'll do it?"
And when I said that.
Yes or no?
Yes.
And at no time during that 911 call are you begging for help, are you?
I don't
Yes
know.
or no?
No, I already had.
Okay. And you were standing in the living room in front of Johnny while he sat in the recliner when he was shot, weren't you?
No.
You weren't
What?
standing in the living room in front of his chair when he was shot.
It happened so fast.
Well, did you pick his body up and put it in the chair?
No, ma'am.
You didn't?
No.
So then we can surmise that you shot him in the chair because that's where he was and you didn't move him. Correct?
It happened so fast, and he was coming at me. If he was in front of the chair, or I don't know where he was at when I shot.
He was coming at you,
Yes.
but he was sitting in the recliner, correct?
I don't know where he was at. I seen him coming, lunging towards me.
Did you pick him up and put him in that chair?
No, ma'am.
But he was in the chair when he was dead, correct?
I don't know how he fell. Apparently, he fell in the chair.
So, okay. So then by your testimony, he was standing up in front of the recliner.
I don't.
Ma'am, by your testimony, he had to have been standing up in front of the recliner, correct?
No, ma'am.
Did you pick him up and put him in the chair?
No,
Your
ma'am.
objection, asked and answered.
Overruled, but move on.
But you agree that he fell in the chair? I'm going to show you what's previously been marked as State's Exhibit 57 for identification purposes. Do you recognize this?
Yes.
Is this the living room where you shot and killed John Norris?
Yes.
Is this John Norris in the chair?
Yes.
Did you pick him up and put him in that chair?
No.
Okay. So we can surmise that he was in front of it, correct?
That he was coming at me. When he come at me, he was in front of that chair. Yes.
Okay, perfect, perfect. So let's pretend that you are in that recliner and I am you. What's right here to my left?
No,
What's
repeat.
right here to my left?
If what?
A sliding glass door?
Who, me?
Yes.
To my left was behind me was the door, a sliding glass door, yes.
Okay, so if the door was behind you, then you're even closer to Johnny than I thought.
Okay, there's a door and there's a patio behind me,
Behind you.
yes.
Okay, so let's pretend this is the apartment. You got a sliding glass door right here. Johnny's in the recliner right where you are.
Over here, on this side.
Sliding glass door, and you're about right here.
I'm on the floor.
Yes
It
or no? Standing up, holding a gun.
No,
Are you on the floor holding a gun?
I grabbed it. As I grabbed it, I grabbed a gun.
Okay, so you grabbed a gun and you're standing up with it.
No, I'm on the floor,
You're on the floor
getting
holding a
up,
gun.
getting up off the floor from just being assaulted.
Okay, and now we're in the living room.
We've been in the living
Okay,
room.
so he's in the chair. There's a sliding door.
He's not in the chair.
He's standing in front of the chair. There's a sliding door, correct? Can't you, even holding the gun, take 4 steps to the door and walk outside?
I wasn't
Yes
holding.
or no?
No.
You can't do that?
Yeah, I guess someone could if they
You
were in
could.
that. I wasn't put in that position.
You're also, if he's in the recliner, and whether you have the gun or not, if he's in the recliner, you can take 4 steps and go out the
Now, we'd
door.
object.
No,
this-
ma'am.
You can't do
Wait
that.
wait a minute.
Not in
well,
my
wait,
position.
There's an objection.
We'd object, Your Honor, it's ask and answer. She's asking the same question because she's not getting the answer she wants.
All right. Yeah, let's go ahead and get this done and then move on.
So anyone else could have walked 4 steps to the door, but you couldn't.
Objection, Your Honor. Anyone else, it's not anyone else. It's my client in this situation.
She said, I couldn't do it in this situation.
Your Honor, she said, could anyone else?
All right. Rephrase the question. Stain.
Could you have walked 4 steps to the door and been out the door? Yes or no?
No.
Okay. Is there also a door outside in the kitchen? A door on the outside in the kitchen?
There's a door in the kitchenette and there's a patio door behind me.
Okay. A patio door behind you and a door in the kitchen.
Yes.
Okay. So you could also have gone out the door in the kitchen.
No.
You have the gun, right?
At the last minute, I mean, it was just a quick
Right.
grab it.
Quick grab. and then you could have gone out.
Because I was
2
just laying on the
doors,
floor
correct?
assaulted, fearing for my life.
Now, within 6 minutes of the 911 call, the police are there, correct?
I don't know how long it was.
Well, the 911 call is 6 minutes long, correct? You saw it
If you
yesterday.
say so, yes.
Okay, so within 6 minutes of calling 911, the police are there, correct? You have to answer.
Yes,
Okay. And when the police get there, Duke is back in the house, isn't he?
I don't know.
Will you open the sliding door and let the dog back in?
No,
You didn't do that?
no,
Okay. Now, you repeatedly told law enforcement and the paramedics that you weren't hurt, didn't you?
no,
You never said that.
no,
You never said that you were fine.
no.
You never said that.
I told them I didn't want to be touched.
Ma'am, do you know that the officers wear body cam? So your testimony today is that you never said you were fine.
I probably said I just didn't want to be touched.
No. My question is, did you tell the paramedics and law enforcement that you were fine?
I'm not clear.
You're not clear?
No, because it's foggy.
Okay. Well, a minute ago you said, no, you didn't say that, but now it's just foggy.
I might have said it, I might have.
Paramedics asked you if you needed to go to the hospital, didn't they?
I'm not sure.
You're not sure?
No.
Well, again, there's body cam footage, so do you remember if they told you that? They asked you?
No.
You signed the pad saying you didn't need medical treatment, didn't you?
I don't know.
Didn't go to the hospital, did you?
No.
You were asked if you were in a fight, weren't you?
No.
You weren't asked that?
No.
I'm going to tell you again. Are you absolutely positive you weren't asked that?
Not to my knowledge.
Okay. Again, when they asked you if you were in a fight, you said no, didn't you?
I'm not aware of the question.
Okay.
You told law enforcement and the paramedics that you fell, didn't you?
No.
You never said that.
No.
Are you 100% sure you didn't say that?
No.
No, you're not sure.
Yes, I'm sure I didn't tell them I fell. Like by accident?
You're
No.
absolutely sure you didn't say that?
I mean, why would they ask me that?
Hold on, all right. All right, you may continue.
You repeatedly stated that Johnny didn't attack you, didn't you?
No.
You never said that.
Not that I'm knowing. No.
You never said that.
No.
You told people that you guys were friends, didn't you?
Yes.
You say today that your back got hurt during this scuffle.
Yes.
But do you recall getting into the cop car when you left the apartment?
Yes.
Do you recall
Thank
saying, I have back problems?
No.
You don't remember that either?
No.
Until today, you've never told anybody that you were in fear for your life from Johnny, have you?
Yes.
You have? Is that a yes?
Yes.
Who have you told that to,
My attorney.
other than your attorney?
I mean, who else would I talk to?
Well, who else do you talk to?
Incarcerated. So who else would I talk to?
You make jail phone calls, don't you?
I've made a couple
Well,
to a couple people.
over 100 in the time that you've been in jail.
I don't know how many.
And until November 10th, you've never told a single person on the jail phone call that you were acting in self-defense, have you?
I just,
Yes or no? Until November the 10th, you've never told a single person this story, have you?
I've not told any story.
You haven't?
No, ma'am.
You've never told anyone that you weren't there?
No.
Never told anyone that strange people came in and knocked you out?
Absolutely not.
Are you positive of that?
Absolutely.
Okay. Now, on November the 10th, suddenly this was self-defense, correct? And you stated that day, right?
Pardon me?
You stated on November the 10th this was self-defense, correct? It's the first day that you decided this was self-defense,
Objection, Your Honor.
correct?
All right. All right, overruled, you may continue.
I want to talk about November the 10th of 2023, okay? Okay?
What's that day? I mean, okay.
You're incarcerated, correct?
Yes, ma'am.
And that day, you start telling that this was self-defense, correct?
Yes.
Time to tell the truth, right? Who's Nathan Swisshelm?
A cousin.
You talk to him on the jail phone calls a lot?
From time to time, yeah.
Is this phone number 937-763-3730?
Yes.
Okay. On November 10th, you finally came clean this was self-defense, correct?
Yes.
You told him that, right?
Yep.
Is that really true?
Yes.
It's actually his idea that this was self-defense, wasn't it? He actually told you that, didn't he?
No.
He didn't.
No.
Your Honor, at this time, we would move to play the jail phone call from November the 10th, 2023, the phone number that the defendant has just identified as Nathan Swisshelm.
I haven't
Go ahead.
identified.
He's going to hook that up real quick so we can get the jail phone call playing and see when you told him, when it was your idea.
United States of America. United States of America. Press 0 to make a prepaid for calls within the United States. Yeah, I was wondering if I should probably know about your head.
We did a day from 6 to 7 o'clock this morning.
Oh, yeah, I'm sorry.
You're all right, man. Actually, Mom called over there, so.
How's she doing?
She's doing all right. They're going to put the scanner on her clock. She's always got something on with her, so I don't know.
Yeah.
She had a surgery done where she dribbles all the time. When he did the surgery, and this still ain't working, so I thought, what the fuck, deal this.
Work on them muscles down there, huh?
Yeah, exactly good. I know just doing there and get dinner when I start the car and rain while that motherfucker by every day for a week. It'll be all right.
I mean, you, buddy, I love you.
Yeah, oh, now, you're boring, motherfucker.
I had court yesterday. I was going to call you, but I figured I was having court here.
We were in town 1 o'clock, Terry, but he did know that was out of court. I was like, what's right up there? If we got kicked out here, like, what's already on this one? I want to go there and wait. She's like, I thought, I'm sure I'm not going on there. It's pretty bad when you're fucking scared to get into the fucking courtroom.
Hell yeah. I know. Garrett walked in and he had to work on it, so they walked him back out.
Oh, yeah.
Yeah.
They left the little fucking, they don't fucking, they don't allow actually, that's for sure.
Mm-hmm. And then Jim was there. That's the big dog. Oh, fuck.
Yeah, they don't fucking around, they do carry all that stuff. I don't know, I think they changed it up a little bit, huh?
Yeah.
Yeah.
I mean, the might as well just fucking lay on the line.
Yeah.
I mean, it is what it is. I mean, you know, if I'm going to the fucking big house and I'm going down the fucking town like it is.
Yeah.
So, I don't know. I mean, the only thing they offered for me was 15 to life. So either take that or take my chances.
Wow.
Yeah. So, well, I think I'm going to gate, then I might as well go down like it really is.
Yeah. Who all was in the courtroom? I feel like Phil's sitting there right there.
His family, Jackie, Jill, Kyle, his mom, Buddy, and I don't know. I think that's it. Might have been a few other people, I don't know. But I just seen them because they come walking in. No, I'm glad that I left town because I needed that, because you know how long our questions where I was at?
Yeah.
Okay, well, I'm not kidding you, for my mental well-being, I needed that. I needed to get out of here, and I needed to see from us, because it is what it is. I mean, you know, when you get brought in here in the middle of the night, and I don't know, and you're fucking...
No, I know what you're saying, and I even look out, he'll even come back where you're at, you know.
Right. So, you know, I don't know, I wanted to call Garrett so bad yesterday, and all I can do is every time I think about it, all I do is just cry. So I know I just call him up and just cry.
Right.
I just so bad for it, so bad. And then I'm trying to call Haley like several times, and every time I call her, I don't even talk about anything about fucking eyes out. I don't know. I just feel so bad for him.
Oh my, really douche.
That's so bad. I don't know. I mean, look at your mom. I don't know. And then
Not worry. Yeah, I know it's easy to say don't worry about everybody else, but I mean, it's right. Everyone's gonna be all right. And nothing can change it now, that's for sure.
Right. And I mean, I don't know. It's just your motherly instinct. You know what I'm saying?
Oh, yeah, fuck yeah, I mean, you should pay more, hell yeah, I know what you're saying. You worry about it, you might be fucking 19 and still you fucking paying more, you know what I mean?
Right? Well, I don't know. It don't matter. It's just sitting out there. It don't bother me. It drives him out, man. It drives him up there. You motherfuckers, none of these people go out there and care about his well-being or drag him out there, drag him off that computer and say, hey, wanna go fishing? Hey, let's go here. Hey, let's go there. Nothing worry about your well-being. And then you think about that fucking house. No, let's not do that. Let's drag him up here to see your mom. That's kind of, I don't know.
Yeah, I see what you're saying.
Yeah.
Oh yeah, I see what you're saying.
Right. I mean, call the town and everything how he's doing. Ask him what to go out to dinner. You know, get right.
Well, I mean, you wanted to come up there, it's all to say, you don't know.
I mean, I know, he wanted, you're right, girl. I know. I'm not
You got a lot of emotions from every direction, you know what I'm saying? You don't know what's in his mind, what's reality, and this, you know, both sides of the fence is, you know?
I know.
If his dad, I mean, it's the dad's brothers and uncles, it's like, your mom is a fucked up situation every direction.
I know.
And he's just a kid to do, so, you know what I mean? 19 years old, Jesus Christ.
Right.
And not vision, and he showed too, Jerry showed the fuck out of her, you know what I mean?
Right. And I was like, you didn't have to talk to him. Nobody to talk to.
All right.
I don't know. I'm gonna stuck, get in here and stuck and locked up. There's nobody to talk to. And you can't talk to nobody.
Well, I already got my hair talk to you, I know that.
It's been fucked up.
Well, they wanted to restart what we call the defense for you, that's for sure, they'll grow on some money either.
Yeah.
If they need to fucking do it, too fucking incompetent fucks, it's hard to say, you know what I mean?
I mean,
Like a serious trial like that.
right. I mean, Bill's pretty much retired.
Right, I mean, small town train,
Yeah.
they're just there for, you know, people like, well, they do, they don't give a serious shit like that.
Right. I know. But, I don't know. Fuck it. I can't change it. You know how I look at it? It's going to be what it's going to be. I'm well aware of this. You know what I'm saying?
Right,
Do you think
right.
that I think that it's just going to, I think it's going to go in my favor, or it's, you know, whatever's going to happen, it's going to happen, whether I have up to $250,000 of an attorney, or I have to work in town.
Yeah,
You know, with the fucking prosecuting attorney, or the fact the acting, it doesn't matter. It's going to be what it's going to be.
Yeah, you know, I mean, this small town system, they all got each other stuff, and they call each other and talk to each other about, you know what I mean?
Right, I know. I know.
I just wonder if it's,
I know. Yeah. I mean, I've questioned 1,000 times whether I wanted JD to be my fucking attorney just because he knows Bill Norris so well. You know, I kind of feel like he's on their side more than he is mine. You know what I'm saying?
It was like schools here and shit, you know what I mean?
Yeah, I mean, and he's got right there telling something that friends they are. I mean, I don't know, and so what do you do?
No,
Think that, you know, pray for the best, I guess, I don't know.
so when your next court date, December 4th and 10th or something like that, or
11 to 12.
11 and 12, okay.
Yeah. But I really, I hate fucking out. I mean, dude, if you help me out until then, I'm out of your fucking hair. We're good. But I didn't fuck money. They're gonna take half of whatever you give me. But I was really fucking with that cheap cigarette. I just need one today.
How much do you do fucking cocktails?
I don't know, she marked $10 on there for the nurse visit, and I had a couple scripts, so I don't know. One might be $3, or it could be $10. I don't know. A few scripts on there cost $3, and a few scripts on there cost $10, so I don't know.
Alright.
So, but if I get a cheap cigarette today, that's $20.
I'll save you some money, and wait, maybe fucking stuff a little bit, I'll get a couple of them, I'll get 2 of them.
Yeah.
Yeah, we can talk a little bit. So like I said, you can sit and beat yourself up and make it worse if it ain't gonna change anything. It's not, it's fucking not.
I know.
You just gotta have to fucking roll the punches and take it out there, and it is what it is.
I know.
You gotta get yourself prepared for the future, you already probably know what that's gonna be.
Alright. I am, that's what I'm saying,
Yeah.
I'm mentally preparing myself for the worst. But
I'll tell you right now, when you leave that fucking place right there, it gets where you're going. The reception there is gonna suck. Yeah, but after that, you have some home place where you're gonna be, let's say, a whole nother fucking world. It's not like it there, I promise you. And you're not even locked up.
that's why I'm so Wagner. I'm like, you know what, if I'm gonna go to 20 years in prison, then if I'm gonna try to keep the paper saying I'm guilty of blah, 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 and take this as a murder charge, and go to 20 years in prison, well, I already grown accustomed to 20 years. I already know accustomed to where I'm at. So why would I do that when I would rather take my chances fucking laying it all on the line and telling them how really it happened? And let the jury decide.
Yeah, you never know.
You know what I'm saying? I mean,
Yeah, right, you never know. 50 years, the 50 years, I'm not saying it's like in 4 years. I mean, you just never know. But what happened, you just never fucking know. You really don't.
I know, so
It only takes one jury person to make it a person.
right. That's what I thought.
And when you fucking start telling me that body slam, something happened.
And that's what I said. I mean, I feel like when I talk to him, I know I don't know if he's on my side or he's scaring me or what, but, dude, I'm telling you.
We're back when this shit originally came down. I can't remember who it was. Someone told me that fucking Johnny was real good at stomping around on women. So I thought we were fucking picture your first next stop, which I still have my finger and face all stored up on that. Damn, what the fuck happened? Did this motherfucker beat your fucking ass or whatever? And then fucking, what's gonna make you leave the house? You got to a fight and you got one with the gun?
That's what I'm saying, like, and it's crazy, and I'm like, yeah, I did, that's exactly,
You know, just fucking shoot somebody for that fucking reason, something.
He told you, right there, this was self-defense.
He'd given me his opinion.
And then you grabbed onto that and said, yeah, that's exactly what happened.
No.
We just heard you.
Oh, I might have agreed with him, maybe.
And that's the very first time from March until November that you ever mentioned anything like that, isn't it?
I didn't have an indictment until
Okay, we'll say July.
July.
Okay, so from July till November, that's the very first time that you mentioned anything about reacting to something Johnny did, isn't it?
No,
It's not?
no.
You repeated that story before?
It's not a story.
So
I didn't talk to anyone
you,
for that purpose of not talking to anyone about anything. I mean, I hadn't even talked to JD really.
okay. Do you recall telling Garrett that you didn't shoot a gun? If you had shot a gun, you would know?
I said it didn't sound like there was a gunshot.
Are you sure?
I don't know.
I mean, are you sure about that as you were about it being your idea this was self-defense?
It wasn't an idea.
So, do you recall telling Nathan on July 24th that if you had shot a gun, you would know because it would kick your shoulder and you would have ringing in your ears?
No.
You didn't say that?
No.
Are you sure?
Yes.
Do you want to listen to that jail call too?
Sure.
Counsel approach.
Okay,
All right, move
so
on.
your testimony today is that you did not say that on July the 24th.
I don't know.
You don't know if you did or not.
Please repeat the question.
Okay. On July the 24th of 2023, do you recall talking to Nathan Swisshelm on a recorded jail phone call?
No.
Okay. Do you recall telling him that had you shot a gun, you would know it because you would have, it would kick your shoulder and you would have ringing in your ears?
I probably said something about to the effect of when you shoot a gun, I know it's loud. You're going to hear it.
Do you recall speaking with Garrett on May the 12th of 2023?
I don't remember.
Okay. Do you recall telling him that you didn't do anything?
Probably, yeah.
Do you recall telling Nathan on April 16th that your voice being on the 911 call, that's absurd? It wasn't you.
I don't even know that I heard the 911 call. In May, I hadn't even been indicted yet, so
Well,
I hadn't even heard a 911 call.
I understand that, but
Today you've testified that you truthfully remember what happened on March the 11th, correct?
No.
You're not truthfully you're not truthfully testifying about what happened on March the 11th?
Yes, I am truthfully testifying on what happened on March 11th.
So whether you were served with an indictment or not doesn't change the facts of March 11th, correct?
No, ma'am.
Okay. So
do you recall saying on May the 12th that you didn't do anything?
Yes.
Okay. Do you recall Do you recall telling Nathan on October 29th that you were being framed, that you weren't, that you did not do this?
Your Honor, we'd object only if our client can recall a specific date. She's better than me. I can't recall a phone call I had last week.
I'm going to overrule the objection.
Do you recall on October 29th of 2023 telling Nathan that you were being framed, that you did not do this?
No.
You don't recall it or you didn't say it?
I don't recall it.
Excuse me.
Now, I want to talk about your story, the story that you testified to when Mr. Wagner was questioning you. You said that when you initially went to reach for the bat, that you and Johnny were 6 feet apart?
Yes.
Okay. But you both were in the living room?
I was in the doorway,
In the doorway of,
the kitchen and the living room.
and where was Johnny?
About on the other side of the chair, like between chairs, but step over probably 3 or 4 steps.
I'm going to show you a picture and have you show me what you're talking about, because
State's Exhibit 22. Show me here where you were,
In the doorway,
and he was
right here.
between the 2 chairs.
Yeah, probably out this way a little bit.
What was-
Roughly right in that area.
Okay. And so you're saying that he was standing here?
Yes, ma'am.
Were there things here in the way?
What do you mean?
Like, were there other things here between the chairs where you're saying he was standing?
I mean, he wasn't standing between the 2 chairs, but if you step out there, he was standing in the living room.
When you picked the ball bat up?
No, when I reached for it. Because he'd done come toward me over his, like he was standing there and took a couple steps. It's my, like he was walking maybe into the kitchen and said, "That's my shirt." And he was like standing right in that vicinity.
so then, and you're grabbing the ball bat.
And I said, "Isn't that Garrett's bat?" And I went to reach for it. And that's when he lunged like over, I don't know if it was over the chair, but I know I got knocked over. And it hit, and there was a gun standing there too, and it hit it.
Okay, so, and then you reach for the gun, and your statement is that you were just gonna put it back up against the wall?
It fell over. I was setting it back up, yes.
So, you guys are, he's aggressive, he's lunging towards you, things are falling over, and you take the time to very calmly put the gun
No,
back against the wall?
No.
Okay. Now, you heard Haley testify yesterday, correct?
Yes.
And Haley didn't testify to anything that you've testified to today, correct?
Yes, because she wasn't there the whole time.
She wasn't there for any of this?
She wasn't there the whole time.
When you grabbed the gun, what weapon did John have?
He didn't have a weapon.
He didn't have a weapon?
No, he grabbed the weapon out of my hand.
Well, you had a gun.
No, I was setting the gun up.
I want to fast forward to the part where you shot and killed him.
Well, this is,
You had a gun. What weapon did John have?
I didn't have a gun.
Ms. Norris, can we agree that you had to have been holding the gun to shoot and kill him?
When you're
Yes
attacked,
or no? Can we agree that you have to pick up the gun and hold it to shoot and kill someone?
yes,
Okay. So when you picked up the gun and you're holding it and you shot him, what weapon was he holding?
I don't know what he was holding.
Well, did you move anything from the chair?
What do you mean?
Like after he died, did you move anything?
No.
I'm going to show you again what's been marked as State's Exhibit 57. This is him deceased in the chair, correct? This is the gun. What weapon did he have here?
I don't
None?
see one. No.
Did you move one?
No.
So he had no weapon.
No.
So when you shot and killed him, you weren't in fear for your life. He had no weapon to kill you with. Isn't that correct?
No.
No further questions.
Redirect.
Melissa. Excuse me, Your Honor. Sorry, Jury. Ms. Collins asked you about, this is my recollection of it, why didn't you try to exit the door to your left or right? You recall her asking you that?
Yes,
You tried to leave the apartment once before, didn't you?
yes.
How did that turn out for you?
Bad.
And when you say bad, is that when you were attacked?
Yes.
Objection leading and outside the scope of cross.
Your Honor, she asked why she didn't try to leave.
Just overruled. It is leading, but I'm going to overrule the objection. I'll let the answer stand, but don't lead.
Ms. Collins asked you if John had a weapon in his hand when you pulled the trigger. Did he have a weapon in his hand when he attacked you the first time?
Yes.
When you went to the door, is that when he had a weapon?
Yes.
Okay. But the second time when you shot, well, not the second time, I apologize. When you indicate, so after the first attack, okay, you got up and where was John?
I don't know. In the kitchen?
Okay. But when you had the gun in your hand, if you recall, where was he?
He was coming through the doorway, coming around towards me.
Back towards you.
Yes.
Okay. And when you had the weapon, why did you fire the weapon?
Because he was coming for me again. You don't think in that moment when you've just been assaulted and attacked and you're just shaking and freaking out. It was laying there and I seen him coming towards me again and I just grabbed it. I didn't mean to shoot him. I didn't mean to kill him. It was just, in my defense, I just grabbed it real quick. It just happened. I mean, until you're put in that position.
One more question.
All right, you may step down, thank you. Do you have any other witnesses?
We would, Restaurant, I believe we've already introduced.
All right, counsel approach. The defense is rested. The state is not going to present any rebuttal, and so that completes the evidence. So we're going to take a recess here. I need to go over a couple of things with the attorneys, legal matters, and then we're going to resume in 20 minutes. So you can go ahead and go outside or wherever you want to go. We'll be back in the jury room in 20 minutes. So it's now 9:50. So at 10:10, you can be back there.
Please rise.
Okay, we're back on record. State of Ohio versus Melissa R. Norris. Counsel and defendant are present. The jury is in the jury room. The defense is rested. State did not present any rebuttal evidence. You wish to renew your motion for purposes of record?
We would, Your Honor, defense counsel would respect to renew our criminal Rule 29 motion, specifically to count to the felonious assault, Your Honor.
All right, that'll be denied. All right, now I did meet with counsel and provided them with the jury instructions. And are there any objections to any of the proposed instructions from the defense?
Not from defense counsel, sir.
State?
Your Honor, I would renew my objection to the self-defense argument based on the testimony today.
Well, testimony was all over the board, I guess, for the best way to describe it, and so I'm not going to get involved in making the factual determinations. That's a role for the jury, so the court will overrule that objection. All right. Then we'll go ahead and bring the jury in. I'll give them the instructions. And then before I do that, I've left my verdict forms. So go ahead and bring the jury in. I'll go get the forms.
Yes, Your Honor. You may be seated, Your Honor. Re-enters the court. Please rise.
Thank you. Be seated, please. All right. We're back on the record in the State versus Melissa Norris. Remind everyone in the courtroom to turn off your cell phones. All right, ladies and gentlemen, the evidence has been presented, and it's now the duty of the court to instruct you as to the matters of law. The court and the jury have separate functions. You will decide the disputed facts. The court will provide the instructions of law. Now, ladies and gentlemen, it's your sworn duty to accept the instructions and to apply the law as it is given to you. You're not permitted to change the law or to apply your own conception of what you think the law should be. All criminal cases begin with the filing of an indictment. Indictment informs the defendant that he or she has been charged with an offense. The fact that it was filed may not be considered for any other purpose. Defendant entered a not guilty plea to the charges in the indictment. Plea of not guilty is a denial of the charge and puts in issue all the essential elements of the offense. Defendant is presumed innocent until her guilt is established beyond a reasonable doubt. Defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offenses that have been charged in the indictment. Reasonable doubt is present when the jurors, after they have carefully considered and compared all the evidence, you cannot say that they are firmly convinced of the charge. It's a doubt based upon reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. Now, ladies and gentlemen, you're the sole judges of the facts, the credibility of the witnesses that were presented, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witness. You'll apply the test of truthfulness that you apply in your daily lives. These tests include the appearance of each witness upon the stand and their manner of testifying, the reasonableness of their testimony, the opportunity that they had to see, hear, and know the things concerning which they testified, their accuracy of memory, their frankness or the lack of it, their intelligence, their interest and bias, if any, together with all of the facts and circumstances surrounding their testimony. Applying these tests, you'll assign to the testimony of each witness such weight as you deem proper. Now, you're not required to believe the testimony of any witness simply because that witness was placed under oath. You may believe or disbelieve all or any part of the testimony. You will determine what testimony is worthy of belief and what testimony is not worthy of belief. Now, each witness was subject to direct examination by the party who called them and to cross-examination by the opposite party. And during cross-examination, counsel inquired into some matters that did not directly relate to the issues. Those questions and answers are permitted for the purpose of helping you determine the credibility and the weight to be given to the testimony and for no other purpose. The testimony of a defendant is to be weighed by the same rules that apply to other witnesses. Now, generally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is submitted for whatever assistance it may provide to help you to arrive at a just verdict. Questions have been asked in which an expert witness was permitted to assume certain facts were true and give an opinion on those assumptions. They must determine whether those assumed facts upon which the expert based his or their opinions are true, and if that a fact is not established, you'll determine its effect upon the opinion of the expert. However, as with all other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of the experts. In determining, in determining its weight, you may take into consideration his or their skill, experience, knowledge, veracity, familiarity with the facts of the case, and the usual rules for testing credibility and determining the weight to be given to the testimony. Now, ladies and gentlemen, evidence is all of the evidence that was received from the witnesses and exhibits that the court has admitted into evidence during the trial. Now, evidence may be either direct or may be circumstantial or may be both. Direct evidence is testimony given by a witness who has seen or heard the facts to which they testify. It includes, of course, the exhibits that were admitted into evidence during the trial. Circumstantial evidence is proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. To infer or to make an inference is to reach a reasonable conclusion or deduction of facts which you may but are not required to make from the other facts which you have found have been established by direct evidence. Whether an inference is made rests entirely with you. Evidence does not include the indictment, the opening statements, closing arguments of counsel, or other statements of counsel during the trial. Opening statements and closing arguments are designed to assist you, but are not considered to be evidence. Any statements that have been stricken by the court that you're told to disregard are not evidence must be treated as though you never heard them. You must not speculate why the court sustained any objection to any question or what the answer to that question may have been. You must not make any inference or speculate on the truth of any suggestion that might have been included in a question that was not answered. Now, a number of exhibits have been introduced, and testimony relating to them has been introduced and admitted into evidence. You may consider whether the exhibits are the same objects and in the same condition as they were originally. You'll determine what weight, if any, each exhibit should receive in light of all the evidence. Now, you may have observed during the course of this trial the defendant's in custody of the sheriff's office. This is not an indication of her guilt or innocence. It simply means she's not been able to post the bond that the court required during the pendency of this action, and you may not consider the fact she's in custody for any purpose. Now, the law under which the defendant is charged in count 1 is entitled murder and is numbered Ohio Revised Code 2903.02a. This law states in pertinent part as follows: no person shall knowingly cause the death of another. The defendant is charged with murder under this section, and before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about March 11, 2023, in Highland County, Ohio, the defendant did purposely cause the death of John W. Norris. The essential elements of the crime of murder are as follows: that the defendant did 1, purposely; 2, cause the death of John Norris; and 3, the offense occurred in Highland County, Ohio, on or about March 11, 2023. It was committed on the exact day as charged in the indictment, sufficient to prove the correct county in which this trial should be held. The state must prove beyond reasonable doubt that any part of the offense the charge was committed in Highland County, Ohio. Now, purpose to cause the death of John W. Norris is an essential element of the offense of murder. A person acts purposely when it's the person's specific intention to cause a certain result. It must be established in this case that at the time in question was present in the mind of the defendant a specific intention to cause the death of John W. Norris as charged in count 1 of the indictment. Purpose is a decision of the mind to do an act with a conscious objective of producing a specific result or engaging in specific conduct. To do an act purposely, it is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to himself or herself unless he or she expresses it to others or indicates it by his or her conduct. The purpose with which a person does an act is determined from the manner in which it is done, the means used, and all the other facts and circumstances in evidence. Now, the purpose with which a person does an act is determined from the manner in which it is done, the means or weapon used, and all the other facts and circumstances in evidence. You may infer a purpose to cause the death of another when the natural probable consequence of the defendant's act is to produce death in light of all the surrounding circumstances. Such circumstances include the weapon used and its capability to destroy life. If you find the defendant used a deadly weapon against another in a manner calculated to destroy life, you may, but are not required, to infer the purpose to cause death from the use of the weapon. Whether an inference is made rests entirely with you. Proof of motive is not required. Presence or absence of a motive is one of the circumstances bearing upon purpose. Where an act is a crime, a good motive or purpose is not a defense. Now, the state charges that the act or failure to act of the defendant caused the death of John W. Norris. Cause is an essential element of the defense. Cause is an act or failure to act which in a natural and continuous sequence directly produces the death, without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act or failure to act. The defendant is also responsible for the natural and foreseeable consequences or results that follow in the ordinary course of events from the act or failure to act. Now, if you find, if you find that the state proved beyond a reasonable doubt all of the essential elements of the offense of murder as charged in count 1 of the indictment, your verdict must be guilty as to such offense according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of murder as charged in count 1 of the indictment, your verdict must be not guilty as to such offense according to your findings. Now, there is a specification to count 1, and a specification is an additional finding made arising out of the facts of the offense charged in the indictment. If your verdict is guilty of murder as charged in count 1, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about her person or under her control while committing the offense of murder, and displayed the firearm, brandished the firearm, indicated possession of the firearm, or used the firearm to facilitate the commission of the offense. If you find the defendant not guilty of murder, you will not consider the specification in count 1. Firearm means any deadly weapon capable of expelling or propelling one or more projectiles by the action of an explosive or combustible propellant. Firearm includes an unloaded firearm and any firearm which is inoperable but which can readily be rendered operable. When deciding whether a firearm is capable of expelling or propelling one or more projectiles by the action of an explosive or combustible propellant, you may rely upon circumstantial evidence, including but not limited to the statements, representations, and actions of the individual exercising control over the firearm. On or about his person, his or her person, or under his or her control means the firearm was either carried on the defendant's person or was so near the defendant's person as to be conveniently accessible within his or her immediate physical reach. Brandish means to wave or exhibit in a menacing or challenging manner. Now, count 2. The law under which the defendant is charged in count 1 is entitled felonious assault and is numbered Ohio Revised Code 2903.11a2. This law states in pertinent part as follows: no person shall knowingly cause or attempt to cause physical harm to another by means of a deadly weapon. Before you can find the defendant guilty of felonious assault as charged in count 2, you must find beyond a reasonable doubt that on or about March 11, 2023 in Highland County, Ohio, the defendant knowingly caused or attempted to cause physical harm to John W. Norris by means of a deadly weapon. The essential elements of the crime of felonious assault as charged in count 1 of the indictment are as follows. That the defendant did 1, on or about March 11, 2023, 2, in Highland County, Ohio, 3, knowingly, 4, cause or attempt to cause physical harm to John Norris, 5, by means of a deadly weapon. Now, the definition I gave you early in count 1 as to the time and the place of prosecution apply to this offense as well. Knowingly. A person acts knowingly, regardless of his or her purpose, when he or she is aware that his or her conduct will probably cause a certain result, or he is aware that his or her conduct will probably be of a certain nature. A person has knowledge of circumstances when he or she is aware such circumstances probably exist. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence, and you'll determine from the facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that the defendant's actions will cause a certain result or be of a certain nature. Again, proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose or knowledge, and where an act is a crime, a good motive or purpose is not a defense. Now, the state charges that the act of the defendant caused or attempted to cause physical harm to John W. Norris, and that is the same definition I gave you earlier in count 1, which will be applied here. Attempt. A criminal attempt is when one purposely does or fails to do anything, which is an act or omission, constituting a substantial step in a course of conduct planned to culminate in her commission of the crime. To constitute a substantial step, conduct must be strongly corroborative of the actor's criminal purpose. Physical harm to persons means any injury, illness, or other physiological impairment, regardless of its gravity or duration. Deadly weapon means any instrument, device, or thing capable of inflicting death and designed or specially adapted for use as a weapon or possessed, carried, or used as a weapon. A deadly weapon is any instrument, device, or thing that has 2 characteristics. The first characteristic is that it is capable of inflicting or causing death. The second characteristic is, in the alternative, either the instrument, device, or thing was designed or specially adapted for use as a weapon, or was possessed, carried, or used in this case as a weapon. These are questions of fact for you to decide. If you find the state proved beyond a reasonable doubt all essential elements of the offense of felonious assault as charged in count 2 of the indictment, your verdict must be guilty as to such offense according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of felonious assault as charged in count 2 of the indictment, your verdict must be not guilty as to such offense according to your findings. Now, the defendant has asserted that with regards to both counts 1 and 2, she acted in self-defense. A person is allowed to use deadly force in self-defense. The state must prove beyond a reasonable doubt in counts 1 and 2 that the defendant, when using deadly force, did not act in self-defense. To prove that the defendant's use of deadly force was not in self-defense, the state must prove beyond a reasonable doubt at least one of the following items. That the defendant was at fault in creating the situation giving rise to the incident between the defendant and John W. Norris, or the defendant did not have reasonable grounds to believe she was in imminent or immediate danger of death or great bodily harm, or she did not have an honest belief, even if mistaken, that she was in imminent danger of death or great bodily harm, or the defendant used unreasonable force. Now, a defendant did not act in self-defense if the state proved beyond a reasonable doubt the defendant was at fault in creating the incident or argument that resulted in the death of John W. Norris. The defendant was at fault if the defendant was the initial aggressor and John W. Norris did not escalate the incident or argument by being the first to use or attempt to use deadly force, or the defendant did not withdraw from the incident or argument. In deciding whether the defendant had a reasonable grounds belief and an honest belief that she was in imminent or immediate danger of death or great bodily harm, you must put yourself in the position of the defendant with her characteristics, her knowledge or lack of knowledge, and under the circumstances and conditions that surrounded her at the time. You must consider the conduct of John W. Norris and decide whether his acts and words caused the defendant to reasonably and honestly believe that the defendant was about to be killed or to receive great bodily harm. In determining whether the defendant using self-defense reasonably believed the force was necessary to prevent injury, loss, or risk to her life or safety, may not consider the possibility of retreat by the defendant. A defendant has no duty to retreat before using force in self-defense if the defendant was in a place in which he or she lawfully had a right to be. Lawfully had a right to be means the defendant was not trespassing when she used force in self-defense. Words alone do not justify the use of force. Resort to deadly force is not justified by abusive language, verbal threats, or other words, no matter how provocative. A person is allowed to use force that is reasonably necessary under the circumstances to protect him or herself from apparent danger. For you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant used more force than was reasonably necessary. Force used was greatly disproportionate to the apparent danger. Deciding whether the force was greatly disproportionate to the apparent danger, you may consider whether the force used shows revenge or a criminal purpose. Now, if you find that the state proved beyond a reasonable doubt all the elements of murder as charged in count 1 and/or felonious assault charged in count 2, and that the state proved beyond a reasonable doubt the defendant did not act in self-defense, you must find the defendant guilty. If you find the state failed to prove beyond a reasonable doubt any of the essential elements of murder as charged in count 1 and/or felonious assault as charged in count 2, or if you find that the state failed to prove beyond a reasonable doubt that the defendant did not act in self-defense, you must find the defendant guilty. Now, if you find the state proved beyond a reasonable doubt all essential elements of any one or more of the offenses charged in separate counts, your verdict must be guilty as to such offense or offenses according to your findings. If you find the state failed to prove beyond a reasonable doubt any one or more of the essential elements of any of the offenses charged in the separate counts of the indictment, your verdict must be not guilty as to such offense or offenses according to your findings. The charges in each count in the indictment constitute a separate and distinct matter. You must consider each count and evidence applicable to each count separately and state your finding as to each count uninfluenced by your verdict as to the other count. Now, that completes the substantive instructions, and just so you know, you won't have to try to remember all this because you will have a copy of these instructions. I do have to make a couple of corrections to some of the things that are in here, but you will have those with you during your deliberations. Now, at this time, we're going to hear the closing arguments of counsel, after which the court will instruct you on your method of deliberation and the means of returning a verdict. Closing arguments are not evidence. They are simply the attorney's argument as to what they believe the evidence has or has not proved. All right, now the state has the burden of proof, and so the state has the right under the law to go first in their closing argument and then to offer a rebuttal at the conclusion of argument of the defendant. And so, Ms. Collins, you're going to give the closing argument?
Yes, Your Honor.
All right, you may proceed.
May it please the court, defense counsel, ladies and gentlemen of the jury, I first want to thank you for your service on the jury. As the judges said, our country is one of the few that uses a jury system to decide guilt, and it only works because of people like yourselves who take your service seriously. And so for that, I want to sincerely thank you. Now, I know that this trial has gone fast, but this is a very, very serious matter. And again, I understand how difficult it is to look at some of this and to pay attention to some of this. And so again, I want to thank you. As the judge said, I have 2 opportunities to speak with you this morning, so I'm going to make the first one a little shorter and to the point. When we started the trial yesterday, I told you the state would prove beyond a reasonable doubt that Melissa Norris decided on March 11th, 2023, that a Cincinnati Reds t-shirt was worth John Norris's life. And now we have proven exactly what I told you we would prove. On March 11th, Haley Pollard, the defendant's daughter, stopped at John's apartment, apartment 6, Tree Woods, here in Hillsborough in Highland County. When Haley got there in the afternoon, John was asleep in his recliner. Haley took the recliner beside John, and when John woke up, he got some coffee. At some point, as they sat and talked, Haley noticed John's t-shirt. Haley pointed out that the t-shirt looked like one that her brother had. And the defendant immediately honed in on this shirt and decided that John Norris had stolen her son Garrett's t-shirt. An argument started, and the defendant grabbed the baseball bat and went toward John. John stood up from the recliner, grabbed the ball bat, before the defendant was able to strike him with it. This is exactly what Haley saw, and this is exactly what Haley told you happened when she testified yesterday. The defendant then grabbed a gun, a 12-gauge shotgun. Let me back up. Haley then left the apartment. She told you that she left, even though John asked her to call the cops, she left because she had a warrant for her arrest. She said that she thought somebody else in the apartment complex would call 911, so she left at that point. After she leaves, the defendant grabs a gun, a 12-gauge shotgun, and she points it at John. Now, John dials 911, and he asks for help. 25 seconds into the phone call, you hear the gunshot blast, and within seconds, John is dead. The defendant then tries to unload the gun, which had jammed. And we know this because she says on the 911 recording, "How do you clear this thing?" It makes perfect sense when you find out that the fired shot shell was still stuck in the shotgun. It didn't expel after she fired it. It makes perfect sense that she says, "How do you clear this thing?" To clear a gun means to remove the fired shot shell from it. And you've had testimony from Detective Butler that that is commonly what is said. Now, Ms. Norris testified today that this happened so fast, she didn't have time to think. It's not true, and we know it's not true because the recorded evidence shows you it's not true. You have a 911 call, it dials. 911, what's your emergency? You don't think I'll do it? That's what she says. She admits that's her voice. She admits that's what she says. 2 other people have identified that voice as hers, and it's very clear that's what she says. You don't think I'll do it? It's not somebody in fear for their life. That person will be, come closer to me and I'm going to shoot you. You don't think I'll do it? Dare me. It's menacing, it's taunting, and it's murder. It's not self-defense. 25 seconds after the 911 call, he's shot and killed. That's a lot of time to think about what you're doing. 25 seconds is almost half a minute. Definitely didn't happen like she said. It happened so fast I didn't have time to think. But you had time to talk. You had time to tease and taunt. But you want this jury to believe you didn't have time to think. Police arrive. Within 6 minutes of the 911 call being made, the police arrive. So in that 6 minutes, what is the defendant doing? You don't have to wonder. We know. You just have to put it together. Haley said that when she was there, the dog was in the house and he was acting kind of skittish. So her mom, the defendant, Melissa Norris, got up and put the dog outside on a chain. Now, 6 minutes later, when Detective Butler gets there, the dog is back in the house. And I brought this evidence out, even though it may have seemed mundane, but it's important because we know that the dog is in the house because Detective Butler said the dog was sitting at John's feet and he wouldn't leave. Detective Butler said he had to call the dog warden to get the dog out of the apartment because he would not leave John. That was the testimony. So we know that in the 6 minutes, when this woman who's been in a fight for her life, that's what she wants you to believe, she's just shot someone. What she does is she goes out and gets the dog and she lets the dog back in the house and she moves around the apartment. We know that she let the dog back in the house for 2 reasons. A, he was in the house. B, the door handles, and you have the pictures, they've got blood on them. We know John didn't do that. The defendant did it. This is not someone that's just been in a fight for their life. So police arrive, and despite repeated requests, the defendant refuses to answer the door. When police finally entered apartment 6, they found John dead, and they find the defendant covered in his blood. The state has answered the question, who and how. The only question is why. Now, they want you to believe that this defendant was in fear for her life and shot John in self-defense. There are so many problems with this claim. First of all, she's never claimed until today that she was in fear for her life from John. John, who suffered from medical problems, had had back surgery on January 5th, and this happened on March the 11th. He'd had discs fused in his back. He has a walker. You can see that in the pictures. He was down to only 134 pounds, and his son, who was his caretaker, testified that he would get winded and have to take a break when he just got up and went from the kitchen to the living room. In fact, he has a cooler and trash can that are sitting right next to his recliner, and you can see these in the pictures. And Kyle told you, Dad had those there because he would get so winded going from the kitchen to the living room. Sometimes he couldn't do it, so he kept a cooler and a trash can right there so he would have something to drink right beside his chair. This woman wants you to believe that this man who was suffering from all those medical conditions body slammed her, tackled her, chased her through the house. The man who is on the phone begging for help tried to kill her. It flies in the face of common sense. The truth is, Melissa Norris shot John Norris because she was mad about a t-shirt. She shot him in cold blood, completely defenseless, on the phone asking for help on 911. She acted in cold blood, first planning to hit John with that baseball bat. And when that didn't work, she found the 12 gauge and literally blew a hole in his head. Literally. Thank you.
Mr. Armentrout, do you have anything?
Please call opposing counsel. Ladies and gentlemen, when I do this, I get really nervous. I'm nervous now. Throat's already dry. Can you imagine how Melissa Norris feels over here today? She's charged with murder. She's charged with felonious assault. We have alleged self-defense because we believe that's what happened. We believe that's what the evidence shows. I first want to touch on the felonious assault for just a minute. And I hope you saw and heard the same case that I did with respect to the felonious assault, because that has to do with the ball bat. It has nothing to do with the gun and Mr. Norris being shot. Haley Pollard testified that when she was there, what I heard was that they were in a tug of war, it was like this, over the bat. There's no evidence that she ever swung the bat at him, hit him, came at him with the bat. The state's pathologist, I think it was, said the wounds were caused by the shotgun. There were no other wounds. His jaw was broken because of the shotgun, not because of her striking him with a bat. You know, Ms. Collins and the state, they really want to win this case.
Objection.
We really want to win this case,
Wait a
too.
minute, okay. Objection's overruled. Argument, this is argument, not evidence, so go ahead.
And what I want to say is, you know, what we're supposed to be doing here is searching for the truth. And if the truth is that the state has proven that, then that's what it is. If the truth is that we have proven self-defense, then you got to let her go. The state presented a lot of witnesses yesterday, and I don't want to disregard them, and I'm sure you're going to hear from it from Ms. Collins. They're important, but they're not as important because Melissa got up there and said, I shot him and he died. So the gun guy, the phone guy, they're all important, but you already know that she shot him. Maybe if it was some other theory, it would be more important than it is. The way I see it, this case comes down really to four important witnesses. The first one was Haley Pollard, defendant's daughter. She testified about the ball bat. She testified about the argument. She testified that when she left, there were no marks on her mother. This has been introduced into evidence. May I approach the mark? You got to see the victim yesterday. Now you get to see what led up to lies. That's what she looked like. That's what Mr. Norris did to her. Haley testified to that. You heard Melissa testify that she had taken a shower that morning. If that was pre-existing, that would be gone. No, it wasn't pre-existing. That's what Mr. Norris did to her. You also heard from Detective Butler. Always does a fine job with his police work. You heard him testify. She's in shock. She's bleeding. And then I think when they get maybe back to the police department, he testifies that she was in shock. Well, maybe she's not in shock now because shooting a gun will bring you out of that. You know, I don't know. I'm not a doctor, and I don't believe that he is either. Next, you've got the state's trying to put this in this neat little package for you. And believe me, she's got a lot more to tell you here in a little bit. But the witness that testified that just doesn't make it fit was Brian Lamb. He testified for the defense today, and you heard what he said. He heard a scuffle. He heard stuff getting thrown around. He heard a woman clearly say, "Get the F off of me." That's what was testified to. So we know that there was something going on down there. Lastly, and the big witness was Melissa. She's testified today. She got beat up on the day that this happened. And she got worked over pretty good today. That's part of what happens. I told you in my brief opening that there would be gaps in her memories, things where maybe she didn't tell the truth. And, you know, Ms. Collins made a big deal that whatever the date was the first time that she claimed self-defense. Well, I can't stand up here and tell you what we may have talked about with our clients called attorney-client privilege. So maybe that's the first time it became known to somebody else. She doesn't have to make it known before this trial. Now, the state's going to may tell you, because I don't really know what she's going to say, that this is just not believable. It's not how you act. You know, the first day in law school, they teach you about somebody called the reasonable person. And I'm going to tell you the reasonable person does not exist. None of us are the reasonable person until you're in a given situation. You don't know what you're going to do, from buying a car to being in a situation where you're defending your life. She shot and killed this man. He's gone. What's reasonable? I don't know. And I don't ever want to know, and neither do any of you want to know. She acted the way she did. She got beat up, and this man got killed. You know, and Ms. Collins will make a big deal about all the time that went by. Something like this would go by just in a flash, wouldn't it? How do you know, through their own witness, she's in shock? So we can't say that she was just in shock when Detective Butler got there. She was probably in shock as soon as that weapon was fired. You heard they played a lengthy phone call for you today. Some of it was kind of difficult for me to understand the tape of it, but you know, you hear this gentleman say she was body slammed. Ms. Collins has gone on that I'm sure he wasn't in very good health. But the evidence is there was nobody in that room besides basically the two of them after Haley left. Not a shred of evidence. She didn't do this to herself, and nobody's alleging that she did that to herself. So, ladies and gentlemen, somehow, and the judge just told you, you have to try and put yourself in that position. I don't know how you do that, and none of us know what would be reasonable at any given moment. But Melissa is not guilty of murder, and I told you that would be a difficult decision, and that's the only decision that you can come to. She was being beaten up. She got the gun, had the gun, and the trigger got pulled, and he got killed. She testified a lot today, and Ms. Collins may tell you that, well, that doesn't make sense because of this or that and the other. It's really not that difficult of a case. But who is the one person that doesn't so-called have a dog in this fight? And that's Brian Lamb. The detectives, everybody works for the police. Haley testified kind of for both ways. But that's the one thing. And, you know, he has said that he had a conversation with Ms. Collins. Why didn't the state call him? Because he doesn't fit into their package. Doesn't. So, ladies and gentlemen, I'm about finished here. There's nothing for me to say because you've heard it all. She's on trial for her life today, and she acted in self-defense, and we're asking you to find the court one. Thank you.
All right, rebuttal from the state.
Thank you.
Here we go.
A few things, just to touch on what Mr. Armentrout said. Haley actually testified that the defendant picked up the ball bat and went after John Norris. And I said, well, were y'all playing baseball in the living room? And she said, no. And then tried to say and was stopped, but why else would you pick up a baseball bat if not to, and go towards somebody if not to hit them with it? We don't have to prove that she caused him physical harm. We have to prove that she attempted to. Had he not stopped her, she was going to hit him. Period. And we know her purpose was death that day because she picked up a gun and took his life. Now, the defense has pointed out, showed you this picture, this 8x10, marched it over in front of you all. This looks bad, right? Except for the testimony was this is not her blood. The testimony from Detective Butler was, no, when you washed it off, there's no cut under her eye. It's just, it's his blood. That close, shoot, it comes back. His blood. All it took was a wash rag. It took a shower. She's booked into jail, showered, no more blood all over her face, doesn't look like a victim anymore. Because it's not her blood, it's his blood. And the testimony was, we asked about this on her eye, this abrasion on her eye, and she said, that's not from today. It didn't happen that day. Whatever had happened to her eye didn't happen that day. It's not even relevant. She said right then, at the moment that they asked her about it, it didn't happen today. Now, I agree with Mr. Armentrout that one of your main jobs is to judge the credibility of the witnesses. And you look at things like you use in your everyday lives. When you decide who's lying and telling you the truth when you're speaking to them. You look at their accuracy of memory, their frankness, their lack of it, their intelligence, their interest, and their bias. And you take all that together with the circumstances and facts surrounding their testimony, and then you decide whom to believe. So there are several, the BCI witnesses and the forensic pathologists. They're fact witnesses. They're just here to deliver evidence to you so that you can see have all the pieces. Everything's there for you. And you have Kyle, who had nothing to gain from his testimony yesterday. He's no bias, no prejudice. He just is relaying facts to you. Detective Butler, I agree with Mr. Armentrout, excellent job. And again, just relayed facts to you, told you what happened. And you heard from Haley. And Haley is not just an interesting witness, but a sad witness. She testified yesterday for the state against her mom. She has no interest in bias. I'm sure she would rather have been anywhere in the world than sitting on that stand telling you what she saw her mom do on March the 11th. She would have rather said, I didn't see a thing. I wasn't there, don't know, see no evil, hear no evil. No, she got on the stand in front of her mom, looked her in the eye, and told you all exactly what she remembered from that day. No interest, no bias, nothing to gain. Certainly nothing to gain. Now, Mr. Armentrout wants you to believe that the state didn't call Brian Lamb because he didn't fit in our package. Well, Brian Lamb, the last thing I asked him, and he agreed with me, is you have no idea what actually happened in the apartment below you, do you? No. Doesn't know who said what, doesn't know exactly what was said. didn't know what the noise was that he heard, thought somebody hit a door, it was really a gunshot. He has nothing to offer. No evidence that can be corroborated, no evidence that can be proven. And the last thing I said was, you have no idea what actually happened. No idea. Nope, guessing. That's why the state didn't call him. It's a guess. Now, then you heard from the defendant, who is the only person with something to gain or lose, the only person with a motive to be untruthful. Every time she answered a question, she was positive. I'm positive about that. Until I said, you know that we have body cam video? Well, I don't recall that. Well, do you remember this? Nope, that didn't happen. Well, I have your jail phone call. Well, I don't remember it then. Every single time, she went from positive to, never mind, I just don't remember, or I'm foggy. She's foggy when it's convenient. She doesn't remember when it's convenient. Now, I want you to look at the elements of the crime. Now, the murder is easy to prove. She's admitted that she shot him. So, there's no question it was on March the 11th of 2023, and there's no question that it happened in Highland County. Everybody's agreed to that. No question that Mr. Norris is no longer with us. No question that the defendant is the reason that he's no longer with us. She ended his life. So you just have to consider what her purpose was. She acting in self-defense? No. She was angry. She's mad about a t-shirt. She wouldn't listen to Haley. Haley said that she tried to talk to her and rationalize with her and say, there are other t-shirts like this. It could, completely irrational. She grabs a ball bat and goes toward John. When he gets the ball bat, she finds a second weapon, a weapon that John couldn't protect himself from. The only person in this scenario that needed protection was John. And he asked for it twice. First, he asked Haley to call the cops. Then he calls 911 and says, I need help. The person doing the assaulting does not call the cops and say, I need help. He was being assaulted. He has a gun pulled on him. Now, upon getting the gun, the defendant acted purposely. She pointed it at him and pulled the trigger, and remember the 911 call. The defendant says, you don't think I'll do it? Again, that's not a woman acting in self-defense. It's a woman that's angry. She's taunting. She's menacing. She's angry about a t-shirt. Now, you can also infer that her purpose was to kill him when you look at page 7 of the jury instructions. You can infer a purpose to cause the death of someone when the natural or probable consequence of the act is to produce death in light of the surrounding circumstances. When you shoot somebody in the head or in the neck, your purpose is to cause their death. And obviously, the gun is a deadly weapon. So, after you find that she's committed murder by purposely taking life, you have to then look at the gun specification. The defendant had on or about her person or under her control when she pulled the trigger and killed John Norris. And on the verdict form, there's a spot, did or did not. We know she did. She admitted it. There's no question that she had the gun on or about her person and brandished it. She shot and killed him. Obviously, she had it. There's no one else that did this. Next is the felonious assault, and this is to the baseball bat that the defendant initially went after John with. Now, she's charged with causing or attempting to cause physical harm. The defense keeps making a big deal, and yesterday they asked Dr. Jenkins, there's no other injuries, right? No. Well, two things with that. Wouldn't you expect him to have some other injury if they're in this big battle for their lives? No, there's no other injury. The only injury is the gunshot wound to the neck. But they asked him this because they wanted to prove that she didn't hit him with a baseball bat. We don't allege that she did. It doesn't say did hit him with a baseball bat. It says did knowingly cause or attempt to cause physical harm. And what did Haley tell you? Had he not grabbed it, she was raising it up. She was going to swing the bat at him. They aren't playing baseball in the living room of apartment 6. She's going to hit him with it. The only reason she didn't is because he stopped her. It doesn't matter that his only wound was this gunshot wound to the neck. We aren't even alleging that she did strike him with it. And again, a deadly weapon is anything that's used at the time as a deadly weapon. And you can look at the purpose here by what she ended up doing. We know that her purpose was to kill, because that's what she did, which means her purpose with the ball bat, to kill. It's a deadly weapon. Now, the state is not required to prove motive, and honestly, it's the craziest motive ever, but frankly, she was just mad. She was mad about a t-shirt. That's what started all this. That's what Haley said. Today, the defendant kind of talked about this t-shirt a little bit. Yeah, I thought it was Garrett's. It's over a Cincinnati Reds t-shirt. Now, the defense wants you to believe that she was acting in self-defense, that her life was in danger, justifying her using deadly force, but there are a lot of problems with this theory. And this is what I'm really going to focus on, because basically she's admitted to the murder. The only question is, was she acting in self-defense? The problems. The first is that John was in the recliner when he was shot in the neck, or right in front of the recliner. If Melissa was truly in fear for her life, can you pull up State's Exhibit 54, please? If Melissa was truly in fear for her life, he's in front of the recliner. So right here, sorry, let's move this just a bit so you guys can see. Better? This is a sliding door to the outside. She is scared to death and fear for her life. She grabs the gun. He's here. She's got about 2 steps to be outside. She doesn't do that. Instead, she points the gun at him and says, "You don't think I'll do it?" She's not in fear for her life. She wants to kill him. That's the first problem. The only permissible use of deadly force against another, and this is in your jury instructions, is if they are using deadly force against you. So the only way it would have been okay for her to shoot him is if he had a weapon that he was harming her with. But she admitted there's nothing. He didn't have a weapon. And I said, well, if he did, it would be right here where he died. He fell over. There's nothing here. And she said she didn't move anything, but there's no weapon there because he didn't have a weapon. He was completely defenseless as she's standing between him and the door holding a shotgun on him. He was completely defenseless. Another problem with the self-defense claim is that an aggressor cannot claim self-defense. It's on page 13 of your jury instructions. Again, the first aggressor cannot later claim self-defense. If they are at fault, they can't claim self-defense. If the defendant was at fault, if the defendant was the initial aggressor and John Norris did not escalate the incident or argument by being the first to use or attempt to use deadly force, this defendant is the initial aggressor. She picked up the baseball bat first. She went after John first. He took the bat, got it away from her finally, and she picked up a gun. Haley was still there as they're battling over the baseball bat. Then she jets out of the apartment as he's asking for help. If the defendant is at rise for causing this incident, she cannot then claim self-defense. There's no question she caused the situation. She got angry about the Cincinnati Reds t-shirt. Now look at John. This is not a man that is 6 feet tall, weighing 250 pounds. Look at the autopsy report, and you'll have it. He weighed 134 pounds when he was shot. He was recovering from back surgery that he had just had January the 5th. He was taking multiple pills every day. There are 3 pictures of pill bottles, all 3 different bottles. He slept in his recliner. There's a walker in the corner. There's a shower stool in the hallway. He keeps the cooler and trash can next to his chair because he Sometimes he can't get to the kitchen. This is not a healthy man. This is not a man that's throwing this woman around. And then look again. We're going to focus back again on this. She literally has him backed in the corner. Literally. She's the one with every way to get away. He's the one that can't get out. Literally, he's trapped in that corner. There's nothing between her and the sliding door to the left. There's nothing between her and the kitchen door. Johnny isn't holding a deadly weapon, but she's holding him in the corner. I'm going to play just the first 26 seconds of the 911 call. We're going to play this, and I want you to remember what her testimony was. This happened so fast, I didn't have time to think. This call proves that is not true. What you just heard is her say, "You don't think I'll do it?" Johnny asking for somebody to please come. I've got a gun pulled on me on my own apartment. And at 25 to 26 seconds after the first ring, as Butler testified, you hear the gunshot. That's an awful lot of time. Not at all how she described it today. It doesn't, the facts, the evidence do not support her version. Period. This is a calculated shooting. She is pointing that gun at him for at least 25 seconds before she shoots him. And we know this because we have the 911 call. "You don't think I'll do it? Hey, I need help. Somebody's here. I got a gun pulled on me." Then as the call is transferring, she shoots. This is not a fight for her life where she has no choice but to grab a gun and shoot. It's not what happened here. Now, look at her actions after the 25 seconds. We have a 6-minute 911 call total. 25 seconds is when the gunshot is. And then she says, "How do you clear this thing?" Which makes sense because the gun was still, there's still the unfired, or the fired shot shell was still in the gun. It was jammed. She tries to clear the gun, and then she lets the dog in. And we know this because Haley told you that before she left, Melissa put the dog outside on a chain. But when Detective Butler entered the apartment, dog's back in the house at John's feet. We have to call the dog warden because we can't get the dog out of the house. So this woman who's just been in a fight for her life and had no choice but to shoot somebody, she's putting the gun down and wrapping it in a t-shirt or in a plaid shirt. You can see that in the pictures. She's letting the dog in the house, taking him off the chain. She's got a coffee cup in her hand, so maybe getting coffee. She grabs the phone that he called 911 with and is carrying it around. These aren't the actions of someone that's been in a fight for their lives. It's just not. This is calculated. She's thinking about what she's doing. Now, you listen to the 911 call. John is the one asking for help. And if she really were in fear for her life, wouldn't you expect her to say something like, "If you come any closer, I'm going to shoot. Stay away from me." It's not what she says. "You don't think I'll do it? Double dog dare me. I'm going to shoot you." It's not a woman in fear for her life. It's a woman that's angry, she's taunting, she's menacing. Most importantly, she's in total control. She's acting purposefully. In fact, once she does fire the gun and kills him, she realizes the gun's jammed and tries to figure out how to get the spent shell out of it. Finally, look at the defendant's story. From March 11th until November the 10th, not one time did she mention self-defense. In almost 100 phone calls, she talks about what happened. I asked her today, do you remember saying things like, if I had shot a gun, I would know? Well, first she said, I never said that. But then when I said, we have jail phone calls, then she changed, well, I don't recall saying that. I said, do you recall saying multiple times, I didn't do anything, it wasn't me? No, I never said that. Well, we have jail phone calls. Are you sure you didn't say that? Well, I don't remember. But then Nathan Swisshelm says, well, I think he attacked you. Yup, that's exactly what happened. Now I'm on it. Self-defense. Now, if it really were a case of self-defense, and Mr. Armentrout asks, you know, we're all expected to be the reasonable person. Wouldn't the reasonable person say immediately, listen, I didn't have a choice. I'm fighting for my life. This man was after me. Look, he did this, he did that. I need medical attention. Instead, none of that happened. You want to know why? Because it wasn't the truth. The truth never changes. Lies change. The truth never changes. And the truth is, she didn't need medical attention because she didn't have any injuries. She didn't have any injuries because he didn't do anything. She blew his head off. He did nothing. He's defenseless. The state must prove each and every element beyond a reasonable doubt. And as the judge said, reasonable doubt is doubt based on reason and common sense. And you can equate that to your own everyday lives. You go to buy a car, you shop around, you collect evidence, the same as you've done in this trial. And you find a car that fits your budget, it's everything you want in a car, reasonable doubt has been overcome, and you buy the car. It's no different than this. It's not a leap. Ladies and gentlemen, the state has proven each element of each crime beyond a reasonable doubt, and I know it's moved quickly and it seems simple. Well, it is simple. John was a man giving a friend a place to stay, and she got angry enough to kill over a t-shirt. There's no rhyme or reason to that. Don't try to ask yourself why. But you can look at the facts, you can look at the evidence, you can remember the testimony, and you can come to only one conclusion. Melissa Norris, this defendant, committed murder when she shot John Norris on March 11th, 2023, and she is guilty of that murder. I'm asking that you find her guilty of that murder with a shotgun. She's also guilty of felonious assault for trying to cause physical harm to him first with a ball bat. Now I'm asking you to retire to the jury room and find her guilty of all counts. Thank you.
All right, thank you. All right, now, ladies and gentlemen of the jury, you've heard the closing arguments, counsel, which I'll again advise you are not evidence. Now, I'm now going to instruct you on how to conduct your deliberations, prepare your verdicts. You must be uninfluenced by any consideration of any sympathy or prejudice. It is your duty to carefully weigh all of the evidence, to decide all of the disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. Now, in fulfilling your duties, your efforts must be to arrive at a just verdict. Consider all of the evidence and use your common sense and make your findings with intelligence and impartiality, without any bias, sympathy, or prejudice, so that the state and defendant will feel their case was fairly and impartially tried. Now, if during the course of the trial the court has said or done anything which you consider an indication, in my view, of the facts of the case in general, you're instructed to disregard that. The court has no right to evade and doesn't desire to evade the province of the jury by indicating a preference between one party or another, and I've not done so. I give that instruction because of something that I had, experience I had 40 years ago when I was prosecutor. I tried a case, and one of the jurors was a client and had come in a few days later about something, and so I asked this person, I said, well, you know, you were on the jury, and, you know, what was your experience, and how did you decide what the verdict ought to be? And this person says to me, well, we kind of watched the judge during the trial and kind of figured out from the way he was making statements and rulings that this is what we should do. And I said, oh my gosh, so, because that's not the way it's supposed to work at all. And so what I always say to a jury is, you know, I just make make the decisions based upon the rules of law, not because I have a preference between one party or the other. So take nothing from anything that I've said during this trial into consideration. Now, other than the instruction of law. Now, you may not discuss or consider the matter of punishment. In the event you convict the defendant of one or more of the counts in the indictment, the duty to determine the punishment is placed by law upon the court. Your initial conduct upon commencing deliberations is a matter of great importance. It's not wise to immediately express a determination or to insist upon a verdict, a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position, even if you later decide you are, maybe or are wrong. Consult with one another, considering each other's views. Deliberate with the objective of reaching an agreement if you can do so without disturbing your individual judgment. You must each decide the case for yourself, and you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you find that it is wrong. However, you should not surrender an honest conviction in order to be congenial or to render a verdict solely because of the opinions of the other jurors. Now, when you go to the jury room, your first function will be to select one of your number as a foreperson. The foreperson you select will preside over the deliberations, but does not have any greater power, nor does that person's vote have any greater importance than anyone else's. Foreperson serves the purpose of helping you to conduct your deliberations in an orderly manner and give each juror an opportunity to express your opinion. One additional duty of the foreperson is to see that the verdict forms and exhibits and copies of these instructions are returned to the court after you've reached a verdict. The foreperson will also be the one to write down any communications or questions from the jury to the court and deliver them to the bailiff. Now, as I've indicated, you will have in your possession the exhibits that were admitted in the case, as well as the verdict forms. And again, those are what will be returned at the conclusion of the case. Now, there were, I forget how many number, 105, I believe, states exhibits, and I believe 4 defendants exhibits. But of the 105, there were actually 3 that were not offered. And so if you're looking for an exhibit, I think it was 39, and I wrote down 82, I forget one other one. But in any event, if you don't have it, it's because it wasn't admitted. Now, also, there are various exhibits in there, some of which have testified and have blood stains and so forth. So if you do decide to handle any of those, the gloves will provide gloves for you and suggest that you do that. You won't have a recording device to replay any recording, so if you decide you need that, you have to let us know, and that'll have to be played here because we can't give you any kind of electrical device to have in the jury room during your deliberations. Now, until your verdict is announced, you're not to disclose to anyone else the status of your deliberations or the nature of your verdict. Now, this being a criminal case, before it can be said that you have reached a verdict in either count, it's necessary for all 12, and I'll repeat, all 12 of the jurors to agree upon a verdict. And so, in addition to the exhibits, as I've explained in the instructions, you'll have 2 verdict forms in the jury room. And the verdict form for count 1, and I'll hold up here to have the name and the verdict to say count 1, the charge, and then there's language, and it says, "We, the jury, have been duly impaneled and sworn, find the defendant, Melissa R. Norris." Then there's a blank space, and underneath that I've got asked, which there's a specification at 1. If you find the defendant guilty of murder, then in that case you will make the decision on the specification. you're to knock on the door. You'll be in the jury room, and again, you'll leave your phones back there on the sill. We'll have a bailiff station outside the door. And if you have any questions, or messages, you can write those out and give it to the bailiff. The bailiff cannot answer questions, so don't ask the bailiff any questions about the case, only, in terms of providing the message to the person, so the bailiff can bring it to me. And then if you have a question, I'll consult with the attorneys and send you back a response. Now, I can't promise you I can give you an answer, because I can only answer questions about what is actually in the record. And so if you ask a question, that something comes up, let's say, for instance, I've seen this in a case before where there was a civil case and the jury had a question. They wanted to know which ambulance arrived at the scene first, because apparently both parties had to go to the hospital. Well, nobody testified to it. Can't answer that question. So if you ask me a question about what happened, I can't answer it. Either you can answer it from the evidence or you can't. But I cannot provide anything to you outside of the record. If you have a question about the law, refer to the substantive instructions. Now, I understand none of you are attorneys, so if you need clarification, ask me that question. I'll probably give you the answer and pointing you to certain portions of the instructions so that you know what to focus on. Or if it's necessary for me to add something I think is appropriate, then I will after I've consulted with the attorneys. Now, it's also about 11:25, so we're going to go ahead and send you back here in a few minutes, in just a couple minutes, and you can start your deliberations. But I know we started early this morning, so I would expect around 12:30, if you have a guilty verdict, that we can adjourn for lunch. If we do, just let the bailiff know. I'll bring you back in just to put on the record that you're going to lunch, what the time is, and give you the reminder about not discussing the case while you are outside of the jury room. The only time you can discuss the case is while you're together, all 12 of you in the jury room, deliberating. All right. Now, is there anything further in counsel?
No, Your Honor, thank you.
All right. Then at this time, Ms. Ramp and Ms. McCrae, Ms. Jurgens, you're going to be excused since nothing has happened that would require any of the first 12 to be excused. Now, with that being said, you are subject to being recalled to come back and participate if something happens during the deliberations to one of the jurors. Somebody gets ill, or there's a family emergency or something like that. So until that happens, and we're also going to have you give your cell phone numbers to the bailiff so that we can call you if that happens. And I've had it happen twice in 15 years, so I'm hoping to get by the next 3 years without that happening again, because it gives me gray hair, but at least a little bit. But in any event, don't discuss the case. Follow all the instructions I've given you so far. Don't read anything about it. Don't post anything about it. We will call you. Someone from the court will call you when the verdict is returned to tell you that at that point then you are released from your obligation and you may discuss the case and your experience if you want. You don't have to, but it'll be up to you. So with that, if you would go ahead and I don't know if you have any codes or anything in the jury room. If not, just come around here, give the bailiff your phone number. Now, ladies and gentlemen of the jury, then I do have to make some corrections to the verdict form and to the instructions, and I'll be sending those back to you momentarily with the exhibits. So at this time, ladies and gentlemen of the jury, if you would just lay your cell phones as you enter the jury room on the ledge there and go into the jury room and begin your deliberation.
Please rise.
Okay, ladies and gentlemen, I understand you're ready to take a lunch break, and that's fine. It's 12, I have 12:40, so we'll give you about an hour and 10 minutes. We'll be back about 1:50. Now, you don't have to go together for lunch and go your individual ways or all together, however you want to do it. If some of you do eat together, do not discuss the matter of the case at all during your break. All deliberations will be conducted by all 12 inside of the jury room. Remember the instructions of the court regarding breaks. You're not to discuss the matter with anyone else. Don't permit anyone to discuss it with you. Don't read anything or listen to anything on the radio, look at anything on the internet, post anything on the internet, or make any statements about your deliberations or anything about the case to anyone else. And so upon your return, I'll have the bailiff note the return of the last one, so we'll note when your deliberations will resume. So please report back by 1:50. You can't take your cell phones with you during the break and then put them back when you come in. Bailiff will be there to make sure that takes place. Thank you.
Please rise.
Go ahead and go. All right, we have we've received a question at 2:04 from the jury. It's a little cryptic, so I'm going to have to bring the jury in and ask them a couple of questions. But at the top of the note, it's written down, what is the definition of self-defense, and then what is the definition is stricken out, but not of self-defense. Second item, and none of these are actually framed in an interrogatory, they're just statements, but they are questions. The second one is daughter's testimony with handling of the bat, definition of position of the bat, and then proof of who started the physical argument. So regarding self-defense, I'll just advance or just point them to the instructions. I'll replay this testimony of Haley Pollard, which would answer those questions, and tell them we'll have to refer to the testimony, not just of the daughter, but of the entire case. And then regarding proof of who started, that's again something they determined from the evidence. Now, while counsel was getting ready to come in, we received another question. Again, actually the first one, this one is legal definition of murder, count 1, legal definition, count 2, felonious assault. So I'm just going to point out to the instructions. So with that, is there any objection to that from any of the counsel? All right. And I believe they found it. Now, we cannot play it through our loudspeakers, but it can be played through the laptop, and we'll put the microphone up there that'll take it through the loudspeaker. So since they updated our system a few weeks ago, we've had some bugs, and that was one we weren't aware of. So hopefully it's going to work. All right. All right, Mr. Strain, if you would have the jury reassemble, please. Be seated. All right, we're back on the record, and State of Ohio versus Melissa R. Norris. The court's received a couple of, the first question we received, I sent back a response. That was the question at 12:30 regarding any video or audio. The second communication we received at 2:04, it says at the top, it was written, what is the definition of self-defense? And that is partially scratched out. And so if you were asking for the definition of self-defense, I'll send this back to you in writing, but it'll be on pages 13 to 15 of the jury instructions. And I cannot offer anything more. That's all of the law that I have to give you on that. And then you ask daughter's testimony with handling of the bat, definition, position of the bat. I assume that means you would like to rehear that testimony, because we don't have it transcribed, we can replay it, and so that's what I'm going to do. It also says proof of who started the physical argument. And again, that's not a question the court can answer. That has to be determined by you from the evidence in the case. And then before we play that, question 3 that came in at 2:30, just as we were getting ready to come into court regarding the second one, legal definition of murder, count 1, legal definition, count 2. Those are also in the written instructions, and I'll refer you to that, but for the record, the elements of murder are set forth in pages 5 through 8, and, well, actually 9, because it has the specification instructions. And then count 2 starts on felonious assault starts at page 9. So I'll send that back to you to point those out to you in writing. So at this time, Mr. Reno, if you would replay the testimony of Haley Pollard.
All right. Call your next witness.
Haley Pollard.
March 2020.
Please state your name for the record.
All right. That's not going to work. We're going to have to take a break here and see what we can do to enhance that. So if you would, just go ahead and retire to the jury room and continue your deliberations, and we'll work on this. Okay, you're going to have to call Jabs and find out what's going on here, because we've got to be able to get money on that. The only other option is that we can take the cable and take this over there and put it on the table, and then put the microphones around it. That would help. But it's too far away over here if we're only going to be able to use the speaker on that. So let's see what we can do. All right, I'll go back and prepare the written responses to those questions I mentioned, and then as soon as we can see what we can do with that. All right, we're back on record. I think we have our technical problems fixed. We've had this system for years, and we've been able to do this routinely, and about 6 or 8 weeks ago, they gave us an upgrade. And since then, had nothing but trouble. You know, you heard the old saying that if it ain't broke, don't fix it. In the computer world, I think it's fix it until it's broke. So, thanks to what my grandson would call hillbilly engineering, I think we're going to be able to work this. We may have to turn off one of those mics. We'll try it and see. Was that you cranking up the? Okay, so just keep it down. All right, so with that, we're going to go ahead and play the testimony.
Are you sworn in the court, clerk's office? All right, we have a seat over there. If you have a cell phone, make sure it's turned on. Yeah. Now, see that light there, that mic, pull that clear to your left. As far as it goes. There you go. Make sure you speak into that. All right, you may inquire.
Thank you. Please state your name for the record. And can you spell your first and last name?
H-A-L-L-E-Y-P-O-L-A-R-D.
Have you watched any of this trial on YouTube yet this morning? Have you recently been convicted of a felony? And are you currently, where are you currently residing? So you're in a treatment facility? And how long have you been in treatment altogether? So have you been clean for that long? Do you know Melissa Norris? And how do you know Melissa? And do you see Melissa in the courtroom today? Can you please point her out for the court? Please let the record reflect the witnesses identify the defendant.
Sword.
Do you know John Norris? And how did you know John?
It's responses.
I want to go back to March the 11th of 2023. Do you recall that day? Did you go to John Norris's home?
Yes.
And where was that at?
Treewood.
Is that here in Hillsborough? And why were you going there?
I was going there to see if I could get a ride to where I was going, which was like Cedar Woods. And he was in the middle of where I was going or whatever, so I just stopped there to see if he could take me direct to the left.
And you know about what time you stopped there? Let's just narrow it down. Was it morning, afternoon, or evening?
I'm guessing probably in between morning and noon, something like that maybe.
Okay. Did you go into the apartment? And who was in the apartment? Who let you in?
My mom answered the door.
And who was in the apartment?
Johnny. He was asleep in his chair.
Now, at some point, what did you do when you went in?
In the morning, I seen he was asleep, and I was talking to my mom like right after we shut the door. And she actually, I didn't know he was going out the door, she was whispering and shit, like I guess I'm trying not to wake him up. And then I actually decided to go back out, but then I'm like, you know what, I don't want to walk, like I'm just going to look him up. So I went and looked him up, and we just started talking.
So where did you go in the living room when you went in?
In the recliner by the left sliding door.
May I approach the witness, Sean?
Amen.
I'm going to show you was previously on the state exhibit 22 for identification purposes. Do you recognize this?
Yes, ma'am.
What is this?
That's his living room.
And, Your Honor, we would ask to admit and tell the state exhibit 22 so the witness can show where she and Mr. Norris were sitting.
Submitted information, publish it.
Thank you. Now, Ms. Paul, is this state exhibit 22 what you just spoke about? Is this the room that you recognize?
Yes, ma'am.
And I'm going to point in a couple different chairs. Who was in this chair? And who was in this chair? And you say John, you mean John Norris?
Yes.
Okay. Now, I'm next going to hand you was previously the Norris Estate Exhibit 52. For identification
That's
purposes.
52 or 62?
52.
52.
Sorry. Do you recognize this?
Yes.
And what is this?
It's I think the rocking chair is where she was sitting across from him.
Whose room is this?
Johnny's living room.
Again, you would ask to admit and publish these so the witness can identify who is where.
Objection. Submitted be published.
Thank you. So now, this is the living room again?
Yes,
Okay, and who was sitting here?
I want to say my mom, but I think the rocking chair was moved over, like she was across from Johnny.
Okay, so over here a little ways?
Yeah.
Okay. And this TV, was it on the floor when you were there?
Yeah, but it wasn't laying over like that.
Okay. Now, in the picture, I'm sorry, let's move forward. Now, what were you guys, if you recall, what were you guys talking about?
John was asking me how I've been doing, I told him, about good treatment, just chit-chatting. I also talked about, like, all the cars in town and all the closet, and that's about it.
Now, at some point, you noticed the t-shirt that he's wearing, correct? What kind of t-shirt was it?
I want to say it's some kind of red.
It's some kind of red t-shirt?
Yes, ma'am.
You noticed the Cincinnati Red t-shirt. Do you say something about it?
Yes, ma'am. I asked my mom if she said that my mom brought out the same shirts. Well, I said it's a different shirt, but we both have the same shirt. And then that's when she started yelling at him, telling her that he took it from here and everything else, and that's how it all started.
When we say she started yelling at him, who? Your mom started yelling at who?
John.
Okay, about the t-shirt. Now, what happened next?
I know she got up and we're so kind of like hollering back at each other. She goes in the kitchen like this, like passing like the door, and like makes a cup of coffee. And then she comes out this way, and it's like a living room. And when she came out this way in the corner, there's a hooded back, and like she grabbed it, and the one was like right up to her hip. John stood up and was standing in front of his chair like this, tugging at the back, like back and forth. And John told me to call the wall. I just ran his red because I knew it was super quiet, and I'm sure somebody on the apartment complex would have called.
Why didn't you say call the wall?
I had work.
You had work. I'm going to show you what's previously been marked as State's Exhibit 21 for identification purposes. Do you recognize this?
What is this? That's Johnny's shirt that he had.
This is the shirt that Johnny was wearing? I'm next going to show you what's previously been marked as State's Exhibit 13 for identification purposes and ask if you recognize it.
What is that number again?
13. You recognize this? What is this?
That's the bag that she grabbed there in the corner.
When you left the house, did you see a doll?
I still don't know it there.
Okay. And what happened with the doll?
So when I was in the recliner, it like came up to me and like I go to pet it and it like jerked really fast because I guess it's been abused or whatever.
were you able to recognize the voices on the 911 call? And who is the female's voice? Melissa Norris, the defendant? And the person that asks for help in the call, do you recognize that voice?
Yeah, Johnny.
Did you see a gun prior to you leaving the apartment?
No.
When you left the apartment, who was in the apartment?
My mom and Johnny.
And that was it? No one else? No further questions?
Excuse me. I have some questions, kind of go over some of the things Ms. Collins said, but I'm trying to put a timeline here for you. Again, what time do you think you arrived at the apartment on the 11th?
I want to say maybe in between 9 and noon, something.
So the lunch hour would be a safe statement?
Yeah, maybe around that time.
Okay. And now, how long were you there?
I was like 15, 20 minutes, not very long at all.
Okay. Now, do you recall during the investigation in this case, you gave a written statement? You wrote a letter. It was dated the 14th. Do you remember that?
I remember writing a statement.
Okay. Did you write your statement the day of the 11th or a couple of days afterwards?
I think it was like a day or two after.
Okay, I'm not trying to trick you, but you did write it the day of the 11th then. Okay. And, good. And you wrote that statement based upon your perceptions of the apartment that day, is that correct?
Right.
So what you saw was true and accurate?
Yes.
Okay. And when you arrived, you indicated Johnny was asleep? Okay. He was asleep in the, I'll say, the rocker to the right, is that correct? Okay. And you indicate he got up at some point. Did you get him up or did he get up on his own?
Yeah, I woke him up.
Okay. And did he go get a cup of coffee? Did he stay seated in the corner?
I feel like Mom she might have bought him a cup, but I don't really remember recall him getting up.
Okay. Okay.
Like to get coffee.
And so he's not up very long before they start out about this teacher, is that correct?
Yes, sir.
Now, you indicated in your statement, I have a copy of it here if you need to refresh your recollection, is that you indicated that Johnny stood up and raised his voice. Is that correct?
Well, they were arguing, but like, I don't recall us saying that. I mean, not, yeah.
Would you like to refresh
They
that?
were arguing back and forth.
Okay, let's see here. That's your statement here. Now, may I approach the witness? Now, this is your statement you gave on March 14th that helps refresh your recollection. You want to take time to read it. On the second page here, go ahead and read that and help refresh your memory. You indicated in your written statement? Okay. You've testified, your statement also indicates that you saw your mom get a baseball bat. Okay. And she had come through the kitchen, and want to say kind of out the back side because it's kind of wrapped around, and she was standing beside Johnny's chair. Is that correct? Okay. As soon as she grabbed the ball bat, if you had to guess, how many seconds before Johnny stood up and grabbed it also?
I would say my mom didn't even get it to like her hip, and Johnny stands up.
Okay. So help me out, because this is very important. So mom grabs the ball bat, and you said her hip. Now, I'm not trying to be cute, not trying to be funny. You know, when she grabs this thing and you said get to her hip, I mean, is she like the batter getting into a batter clock, get her to clock you, or is she just grabbing the handle?
So no, I mean, I want to say that when she picks it up and like she's just like picking the ball, like the ball back up, like you say you're going to hit a ball, but I think there was no chance, so she didn't have time to swing it or nothing. She just stood up and
Yeah, so she didn't get the bat above her hip high. Is that what you testified to?
right. When she grabbed her, it looked like nothing got to her hip.
As soon as she grabs it, is it a fair statement? Johnny and Lee grabs it right after.
Yes.
Okay. Now again, I mean that this is important for us. You know, are they sitting there, both of their hands on the handle of it? Or does one of them have the handle and one of them have the head of the bat like a tug of war?
So they're standing in front of each other. Like here's the chair, and they're like this.
Okay.
And the bat's long, and he's pulling like this, and she's tugging like this, and they're just like tugging, screaming back and forth.
So that's very pushy.
Yes.
Okay. So if we were on our job, I thought it was that.
No, it's not wrong, it was wrong this way.
Oh, okay.
Like standing in front of me, it was wrong. Yeah, she's like this.
So we're going to that like this. Okay. And at this time, did your mom swing the bat at John? No. At the time, so she never struck him with it.
So they didn't get physical at all, they didn't, they were ready to go out of things.
So when she didn't, and your statement doesn't indicate, she didn't threaten, hey, you SOB, I'm going to clock you with this bat?
Hey, what?
She never threatened him with the bat, did she?
No, but I just wanted to.
Okay, you're fine. So again, at some point then, how did they put the bat down, or did you leave at that
So
point?
they're actually still tugging back and forth when he tells me to call wall, and I just left.
Okay, so you took off.
Yeah.
All right. Go back and approach the witness. What I have marked as State's Exhibit A and B.
Defense.
Defense. Did I say state? No. Defendants A and B. Ma'am, here is A. You recognize who's in that photo?
Yes, my mom.
Ms. Collins asked you about when I picture this again, about defense C and D. This is defendant C. That's the one that we were talking about. You tested.
another picture of it. Blow it up. Now, that monitor, was that in that position when you left the apartment?
The TV?
The TV?
No, it was sitting up, straight up.
It was sitting up, okay? And is that the chair that your mom was sitting on?
No, I feel like the chair was, she was sitting across from John.
Okay. So, according to your recollection, the chair has been moved, and the mom was knocked over, correct?
Yeah.
And so that picture does not depict the same, I'll say, scenario or scene of the apartment when you left on the 11th, correct? No further questions, Redirect.
Thank you. Mr. Wagner used the word injury when he talked about those pictures of your mom.
May approach, it was previously marked as Stacy lived at 105.
Do you recognize the person in that? And do you recognize what kind of photo that is?
It's a little shot.
The booking photo? Do you see any injuries to her face in that?
Yeah, I was like, she was a bruise on the kind of her face.
But this injury, as Mr. Wagner calls it, here on her face, all the blood and stuff, it's not on the pictures. But no injury back under her eye or is there?
Yeah, I thought I would have seen it.
One other question. You said that she grabbed the ball bat and Mr. Wagner
Said, well, she didn't swing it. You remember that? Well, what was she going to do with it?
Objection, Your Honor.
I'll sustain.
Were you guys playing baseball in the living room?
I was just about to say, I don't know why she would grab that, she wasn't.
She said she didn't know, so.
No further questions.
All right, make that down. Next witness.
Chris Campton?
You go.
All right, that completes the testimony, ladies and gentlemen. Again, I apologize for the technical problems. So you'll return to the jury room. Now, again, in deliberating, you consider this, the replay, the same as all other evidence. In making your determination. And again, the instructions I've said are in your instructions. Anything you would ask me about the law is there. I would just read it to you. So perhaps if you got if a question comes up, you might ask one of your number to read the instructions, because that's just basically what I would do. So, all right, if you return to the jury room, please. Okay, we're back on record. State versus Melissa Norris. Courts received a fourth question at 4:02. Question was, does the felonious assault charge only apply to the bat or either the bat or shotgun? And then they also brought back, oh, I left that in my chambers, I'll get that. They also brought back or sent out the jury instruction. That's on my desk, Dan. And they pointed out that on page 18, what I had in the jury instruction said, when reading the jury form for count 2, it said a blank space of felonious assault, a felony of the first degree. It's actually a second, and the second is on the verdict form. I read it as a second degree. I believe counsel agrees with that, and it's on the form. So the form's correct, and I read it correctly. So my response to that is the verdict form for count 2 is correct. Page 18 was a cut and paste error. My oral reading of the form is correct on the record, but thank you for catching it. All right. Any objection to that, counsel?
No, Your Honor.
All right. Yeah, they also sent out the verdict form for the record, and it's being returned with their copy of the instructions and the answer to the question. All right, thank you. Go ahead, Lisa. All right, the jury has returned to the courtroom, and it's my understanding that the jury's reached verdicts. Is that correct, Mr. Foreman? Yes. You would hand that to the clerk, please, both the verdict forms. All right, Mr. Hodson, if you would read the verdict forms, please.
In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Melissa R. Norris. Case number 23CR137. Verdict, count 1, murder, revised code 2903.02A. We, the jury, having been duly impaneled and sworn, find the defendant, Melissa R. Norris, guilty of murder, an unclassified felony, as she stands charged in count 1 of the indictment. We further find and specify that the defendant did have a firearm as defined in revised code 2923.11 on or about her person while committing the offense, and displayed the firearm, brandished the firearm, indicated that she possessed the firearm, or used it to facilitate the offense. In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Melissa R. Norris. Case number 23CR137. Verdict, count 2, felonious assault. Revised code 2903.11A2. We, the jury, having been duly impaneled and sworn, find the defendant, Melissa R. Norris, not guilty of felonious assault, a second-degree felony, as she stands charged in count 2 of the indictment.
Thank you, Mr. Hodson. All right, the court will note that the forms are signed by all 12 jurors, and I'll ask at this time of all 12 of you, is this your verdict on each of the 2 separate counts? All of you concur? All right. You wish the jury poll?
No.
All right. All right, then the court accepts the verdicts as returned by the jury and enters a finding of guilty of count 1 as found by the jury, and not guilty as count 2. Ladies and gentlemen, I want to thank you for your service here today, and your deliberations were thorough, and you asked a lot of questions, and that's fine. That's good that you do that. And you caught one of my typos. That escaped all of our eagle eyes because we all went over it, and I read it correctly, but I didn't read it from the instructions. I read it from the form, so that's why I didn't catch it. But I thank you for that thoroughness. And your service is important to the community because, as we talked about yesterday in the voir dire, this is the way that we protect our constitutional right to a jury trial, is by citizens like you participating. So I thank you for your service. You should not be called again for the rest I know you won't be called again the rest of this month, and then you are exempt for 1 year. So our computer should not draw you next year. If by chance it should, it happens once in a while, once every few years. Just call and point out you were on service this year. So you won't be called in 25, you'll be back in the pool in 26. So with that, you can go ahead and retrieve your cell phones and report down to Mr. Hodson's office to claim your pay vouchers and if you need anything for work, a work excuse, then you can do that. And I'll ask all the spectators and counsel and everybody to remain in the courtroom while the jury exits. So, thank you. All right, everyone can be seated. All right, there is only one sentence provided by law, and so the court is going to go ahead and proceed with sentencing. However, I do know that the state may want to consult with the representatives about talking. Do you need to have a few minutes to organize that, or Would you be ready to go for
I
it?
think we'll be ready to go in about 2 seconds.
Okay.
Okay. We have one person that would like to speak and then 3 statements to read, Your Honor.
All right. All right, well, this time, do you want to say something first, or want to wait till after the others speak?
Your Honor, there's only one possible sentence in this case, so
Okay.
with that, I would just ask the victim's
Okay.
family to be allowed to
All right.
address the court.
Okay, if you would state your name, please. State your name, please, for the record.
Becky Norris, Novak.
Go ahead.
I know it's really hard for anybody to fathom how something like this could happen, but I believe that how it began started many years ago on the way back from Talladega, getting smacked in the rear end by somebody that was on meth, driving about 90 miles an hour. It gave somebody a pain in their back and a pain pill problem that escalated to meth addiction that rolled into the last guy that Melissa was seeing overdosed in July of last year, I believe. And just everything's just rolling and rolling and rolling from being on pain pills and then meth to finally completely out of control. And I believe that Melissa knows that that's exactly how everything happened. And we know that Ohio has an opioid problem. And the opioid problem didn't just start 2 weeks ago, it started 20 years ago. So I know some things might be beyond people's ability to be able to comprehend how things can happen. But if you watch videos of people that's been on meth for that long, sometimes they have no idea what they're doing. And I believe that Melissa did love Johnny, but I believe that consuming and consuming and consuming and consuming and consuming meth and not sleeping and not eating makes a person a demon. And I think that's what happened. And I thank everybody for listening to what my brother had to say when he said that he was being held at gunpoint in his own apartment. Because he could have had a pain pill problem like that too, that could have escalated into things, but he was trying to get better. And Melissa was not trying to get better. And Johnny was trying to heal from everything, and to take the life of somebody that was kind enough to give you a place to stay when you've already run yourself out of every other option over a 20-year course. I think that's really cruel. And I think it was probably about July of last year that Melissa quit caring about anything. And she didn't just kill my brother Johnny, she threatened to kill my brother Jerry too, before this. And I know she would have done it. And I know there's no way that I could even be around her for the last couple of years, that there's no way. Because I'd have to turn around and walk away from somebody trying to tear me down too. So we didn't take anything from Melissa. Melissa let her life be taken away from her by her choices over a long, many years. And that's all I have to say.
Thank you. All right, who's going to read the statement?
She's just going to try to read hers.
Is she just going to read the statements or is she going to
She's
speak?
going to try to read hers, and then I'll take
Okay.
over if that's okay, sir.
All right. Would you state your name, please?
My name's Jackie Mitchell. Thank you, Your Honor, for allowing me this opportunity to say a few words about Johnny. My name is Jackie Mitchell, and Johnny was my brother. On March 11th of this year, my world fell apart when I received that devastating phone call. When I found out how Johnny died, I just couldn't believe it. Johnny wasn't just a brother to me. I have 5 brothers and I love each of them. But Johnny was the goofiest and the most handsome and soft-hearted of them all. Also, none of us is shabby in the musical arts, but Johnny was by far the most talented of us. We'll never hear him sing tenor again, or watch him effortlessly pick through some gnarly, amazing guitar solo. He'll never again accompany when we sing Marty Robbins or Patsy Cline or any other twangy bluegrass or country song. I can't do this anymore.
All right, Ms. Collins, do you want to go ahead and continue to read the rest of that?
He'll never again accompany when we sing Marty Robbins or Patsy Cline or any other twangy bluegrass or country song. He won't sing Go Rest High at anyone's funeral. And as a matter of fact, Kyle had to sing that song at his own dad's funeral at 22 years old. Johnny has always said, treat others the way that you want to be treated. He didn't treat Melissa the way she deserved to be treated, though. Even though she was always looking for a handout and a place to sleep, but wouldn't do anything to help herself, Johnny always treated her with kindness and compassion, whether she deserved that or not. She probably didn't deserve a place to sleep last Christmas Eve, but Johnny couldn't stand the thought of her sleeping in a car in 3-degree weather. So he let her sleep in his apartment. That same thing happened again in March of this year, and instead of thinking about how much she wasn't doing anything to help her own situation, Johnny only thought to treat her the way he thought he would want to be treated. He treated her with kindness and compassion, even though she didn't deserve it. I'll never forgive her for how she has betrayed him. Even seeing Johnny's bloody and lifeless body on your large screen didn't seem to faze Melissa, but she was visibly bothered by her own distraught panting on the 911 call, because she seems to see herself as the victim in all of this. I don't think she feels guilty or remorseful for what she's done. While she herself seems oblivious to the harm she's caused to this family, there are other family members, her own son and daughter included, who are very remorseful for her decisions she made earlier on March 11th. Her own daughter regrets not calling 911. Her youngest son blamed himself for not hanging out with her because he said that then she would have been hanging out with me and she wouldn't have shot Uncle Johnny. Her ex-husband, my brother, Jerry, feels guilty for even bringing her into our family. I'm not typically a hateful and vengeful person, and I normally don't wish bad things on anyone, but I hope she never gets out of prison while she's still physically capable of causing harm to anyone. It is my desire that she never get out of prison. Thank you again, Your Honor, for allowing me to express the impact the actions of this selfish and hateful person have had on me and my family. Please sentence her to the maximum time allowed by law. It's what she deserves, and it's what Johnny deserves. This is from Jamie Norris. Your Honor, thank you for letting me speak for Johnny today. My name is Jamie Norris, and I am Johnny's baby brother. Johnny always protected me and taught me how to do things. When things in life were bothering me, Johnny was who I always called. I would also call him when good things would happen. Now I don't know who to call to talk to about these things, either good or bad. Johnny was a lot of different things to so many people, but the one thing he was to everyone was kind. He was the most kind and most sincere one out of 8 of us kids, which isn't saying a lot sometimes. Johnny was one of the kindest people I have ever met in my 47 years, and I have been a lot of places in this world. It would be easy to say that Johnny was one of the kindest people in Hillsborough. I mean, he was giving this woman a place to shower and charge her phone until she could get her car out of impound, which was no doubt an impound as a result of another bad decision this woman made in a very, very long list of bad decisions she was allowed to make. Those decisions have accumulated now with this unforgivable crime. Her decision to pull that trigger and take my brother, father, uncle, future grandpa, Johnny, should be the very last decision she was allowed to make as a free member of this society. She has been allowed to take away so much happiness from this family, which she was brought into with open arms. She has mercilessly destroyed her own family in the process of destroying her own life and taking Johnny's life. She needs to never be allowed to walk free again. She should never be allowed to cause any more harm to the Norris family or her own family, her children, one of which has the last name of Norris, who wants absolutely nothing to do with her after this, ever. It may not be too late for her children to recover from the damage she has done, but it is not going to be easy for Johnny's son, Kyle, or Kyle's future children who have lost the privilege of meeting their grandpa, Johnny. It is beyond too late for this woman to be a productive member of society. I personally wish there were harsher sentences for murders and other violent offenders. But since there isn't currently, I hope she's never allowed out of prison until the day after she breathes her last breath, because I know that I won't go a single day without thinking of what she has done to Johnny and his family until I have taken my very last breath. And I know the same could be said for a lot of people, especially Kyle. He's only 22 years old. Please, 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 make it mathematically and biologically impossible for her to affect this family in any way in the future. The only hope that I have for her is that every time she hears a pick hit a string, she thinks of John Wesley Norris and that unspeakable thing she done.
All right, is there anything else from the state or any other person who would like to speak?
No one wants to speak. I'm sorry.
All right.
I'm sorry.
There's a lot of papers and everything.
There is one more. Who's it?
Shonda's. This impact statement is from Shonda Bowline.
Sorry, what's that?
This impact statement is from Shonda Bowline.
Okay.
Good afternoon, Your Honor. I am writing to express how the murder of John Norris has negatively affected my son, Kyle Norris, Johnny's family, myself, and our 2 other children. March 11th, 2023 was a nightmare we could not wake up from, for all of us, to say the least. The call I received telling me that Johnny was no longer with us will be forever be embedded in my mind. I questioned so many things this day. How? Why? And how am I possibly going to tell our son that his best friend was taken from us just because of a t-shirt? A t-shirt was more important than a life. March 11th, 2023, the day that has negatively changed our lives forever as a person that meant so much to us, was taken away from us by such a maliciously violent crime over a t-shirt. Our hearts are shattered into a million pieces that will never be able to be mended. I personally spent 3 years of my life with Johnny, and as a result, we share our precious son, Kyle Norris. Johnny was a giving, loving, and thoughtful person who only wanted the very best for everyone he met. He loved my other 2 children as though they were his own from the very start, and never failed to tell them how much they meant to him, and continued to remind them throughout the years, even after our relationship had ended. Johnny and I continued to remain friends, and he never failed to remind me how much he appreciated the mother I was to our son. He was a gentle and kind soul that was more willing to help anyone that was in need any time they crossed his path. How does someone take the life of a person that has opened their home to them on multiple occasions and provided them with a warm place to stay, even though he didn't have to? Melissa Norris did just that. She didn't take into consideration the numerous times he provided to help her and her children, cared for her children, or even the impact she would have on so many lives by engaging in such a horrific act. I would now like to address the negative impact this has had on our son, Kyle Norris. I watched as my son provided continuous and utmost care for his father while he was rapidly declining in health. The countless nights Kyle would not even sleep just so he could make sure his dad didn't need help to the restroom, have a seizure, where he would have to catch his dad as he was falling, or wasn't in excruciating pain from a neck surgery, just to name a few. Then he would go to work the next morning with no sleep, like clockwork, come home and repeat with no complaint. Those were some huge responsibilities for a young man in his 20s, but he did it because he loved his dad beyond measure and being there for him. The 2 shared a very special bond in music and baseball and so many more areas of their lives. Our son will now never again get to play a gig with his dad. His dreams of continuing their band together are now shattered. He will never throw a ball with his dad or get his dad's advice when life throws him struggles, and most importantly, will never ever get to hear his dad say, "I love you," or "I am proud of you, son." Since this incident has occurred, I have watched my son suffer from severe insomnia, resulting in the loss of his job, lost wages to attend multiple court hearings, not to mention the mental and physical toll it has taken on him. These are the things that were ripped away from my son in an instant by Melissa Norris. I fear that a person with this kind of malicious intent to harm others is a risk for not only my family and the Norris family, but also to society. Therefore, I believe Melissa Norris should have to face the charges against her. Thank you for taking the time to hear how this negatively impacted myself and those who meant so much to not only myself, but those who Johnny loved with all of his heart.
All right, anyone else?
No, that's all you want.
All right, on behalf of the defendant, either counsel wish to speak?
Only, Your Honor, on behalf of Ms. Norris, myself, Mr. Armentrout, I don't think there's much leverage here or mitigation that one can offer. I think we're bound by the sentencing guidelines. I would just personally say for myself and Mr. Armentrout, my condolences to the Norris family. It's tough to lose a loved one. I know where you're coming from. I can offer my apologies to you guys. Your Honor, we're bound, I think, by the sentencing, so there's no real mitigation I'd offer at this time.
All right, Ms. Norris, if you would like to say something on your own behalf, you may. You're not required to, but I'll consider whatever you would like to say.
Not at the present time, Your Honor.
Pardon me?
Not at the present time, Your Honor.
All right. Well, first of all, I want to say that, Mr. Norris certainly sounds like an outstanding individual, had a very loving family, and I've been impressed by not just what they've said here today, but how they conducted themselves through the trial, because I've been involved in many, many cases where people are so angry and seeking revenge, so to speak, that their emotions get the better of them. So, again, I think that all of you who have been here to support the prosecution and in your loss have acted very admirably, and I appreciate that. It's hard to understand why he would have taken you in the first place. Obviously, it says a lot about his character. You know, you're the ex-sister-in-law. I have ex-in-laws both ways, and, you know, I doubt that, you know, any of us would feel comfortable in taking in one another, no matter how bad our situation were or was. And so the fact that he was willing to do that says a lot. And the way you conducted yourself says a lot about you. Well, it says everything. There doesn't seem to be any particular, I mean, it's a senseless murder. That's all there is to it. It's senseless. And, you know, your explanation, granted, it's just the two of you were the only two who were there and know what was happened, but what we do know is this, that I think that the entire case comes down to the 26 seconds, first 26 seconds of that 911 call. And the first words you can hear is you saying, "You don't think I'll do it." And then him saying that, you know, he has a gun pointed at him in his own apartment. And then you can hear the pop, and then your comment is, "How do I clear this?" And that's it. And then afterwards, you have his phone. You know, it would be a reasonable inference to say that he must have had it in his hand at the time he was shot, and that you picked it up because it moved around and was walking around. You could hear breathing. Obviously, you were the only person there that was still alive. And despite the efforts of the dispatchers to try to get you to communicate with them and your opportunity to claim self-defense at that point, you didn't even speak to them. You didn't acknowledge them. And, you know, I mean, the jury didn't buy your explanation, and I can understand why, because it doesn't, you know, as the old saying goes, doesn't hold water. It has a lot of holes in it. And so, you know, certainly justice has been done in this verdict. There is only one sentence permitted by law under the 2914. The court must impose a sentence of 3 years for the conviction of the firearm specification under 2941.145. And so it's ordered the court that you be sentenced to the Ohio State Reformatory on the gun specification, Ohio State Reformatory for women at Marysville, to a mandatory term of 3 years. As to the murder conviction, the sentence is only one sentence provided by law, and it's ordered the court that you be sentenced to a term of 15 years to a maximum of life. And by law, those sentences are ordered to be served consecutively to one another. And you have, according to the sheriff, 155 days of jail time credit as of today. That will be credited against that. Now, upon completion of the prison term, it will be mandatory that you be put under post-release control supervision for a period of 5 years. You'll be supervised by a parole officer under those terms set by the Adult Parole Authority. And if they determine that you have failed to comply with those terms, they can return you to prison to serve an additional period of 9 months for any one violation, up to a maximum of half of the prison term for all violations. But if you're convicted of a new felony, then you would be subject to being sentenced to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater for committing that offense, while under post-release control in this case, and that would be required to be served consecutively. And you would also be under parole, because 15 years to life if you're released before you die. Then you would also be under parole, but that would be under different conditions. But the law still requires post-release control supervision to be served. It's also ordered the court to pay the court costs, which judgment, grant, and execution is ordered. If you fail to do that, the court can, the clerk of courts can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then should you be released from prison, the court could permit you to do community service in this county and give you credit for each hour you work in an hourly rate set by the court. Each hour you work, reduce your judgment by that amount until paid in full. Now, I'm informing you, Ms. Norris, that you do have a right to appeal this conviction. Normally, I would say the conviction and the sentence, but the sentence is just one. There's only one sentence to be imposed, and it's mandatory. So, as a practical matter, there's no right to appeal that. But you can appeal the the verdict of the jury and the conviction. If you wish to appeal, that must be filed within 30 days of your entry of sentencing being filed, which will be tomorrow. You have the right to have all of the papers from the case that were filed in the case, as well as a transcript of all the proceedings in the case, all the hearings that were held. And if you do not have the funds to pay for those, then the county will provide those to you at no cost. You have a right to have an attorney to represent you in your appeal. And if you do not have the funds to hire an attorney, the court will appoint one for you to prosecute that appeal. And again, that would have to be filed, the notice of appeal would have to be filed within 30 days. I assume counsel will discuss that with Ms. Norris. My general recommendation and request is that I know that traditionally trial counsel does not prosecute the appeal, so if you would file the notice of appeal to protect her right, and then notify the court of whether you're going to be willing to continue on the case or not. If you're not, then at that time the court would contact appellate counsel to appoint to prosecute the appeal. All right, is there anything further, counsel?
I just wanted to confirm, 155 days of jail time credit?
Yes.
Okay, that's what I had written down, just wanted to confirm.
All right. Anything further?
No.
All right, you're remanded in custody, Ms. Murphy.
Please rise.